Yes.
May I please, Lord? My Lord, item 45 may be upgraded, my Lord.
45.
Yes, my Lord. On the last two person, my Lord, it was listed, but not.
Why?
My Lord,
Why?
Upgrade why?
Why you asking for upgradation? Why are you requesting for upgradation?
my Lord, for consideration of interim, my Lord.
Okay.
Obviously. May I please, your Lordship?
Yes.
Lordship, I beg to mention item number 24 and 37, my Lord. It adjourned only for 2 weeks, my Lord.
24 and
37.
24 and 33. You are not there.
No, I mean, 24 is Abdul Quddus, and 37 is B. Chaudhary, Papan Chaudhary, my Lord. 37.
24, you're not there, no?
No, I am not there, my Lord. As per the instruction of AK Abdul Quddus and B. Chaudhary, my Lord.
Abdul Quddus, there is no advocate Abdul Quddus here.
AK Quddus. 24, item number 24.
A.K. Hussain is
AK Hussain, my Lord. Abdul Quddus Hussain, my Lord.
Oh,
AK Hussain, that is Abdul Quddus Hussain.
okay. 24 and 33.
37.
37. 37 also.
B. Chaudhary, my Lord.
Okay. 37 and 24. Both sides are represented on the prayer made by
Mr.
Mr. F. Hassan, Learned Counsel, on instructions of the Learned Counsel for the petitioner. The matter stands adjourned today after 2 weeks.
Yes, obviously, Your Honor.
Lordship, for illegal action of the police, I have already filed a writ petition. That was supposed to, yes, on 2nd, that was listed for filing affidavit on the side of the government. But that was left out on that day, Lordship. In this case, certain development, I have filed an affidavit, IA petition. May be taken up today, Lordship.
Not today. Today is a long
Tomorrow,
list.
Lordship.
Not tomorrow, day after tomorrow. Tomorrow there is a disruption in bench.
the holiday, Lordship.
Day after
Oh, no,
tomorrow.
not there. Just on Thursday there will be disruption of bench. That's why. Friday.
Friday, Lordship, it is very urgent regarding.
No,
Tomorrow,
the bench, there will be a special bench on that day.
Thursday.
Thursday.
Lordship, it's possible tomorrow. Lordship.
Day after tomorrow is again a holiday.
Friday, my lord.
Okay, then tomorrow. Okay.
Tomorrow, obliged.
Let us see if she's got urgency.
May I please, your lordship? Item number 10, lordship. This matter may come after 2 weeks.
10.
10.
Okay, after 2 weeks.
Keep your right.
My Lord, I beg to mention item 18 and 43. We accommodate for the DIM.
Okay.
18 and 43.
18 and 43.
My Lord.
But it goes for 2 weeks.
My Lord.
18 and 43.
43.
Okay.
Grateful. Make please, I beg to mention item number 15. May kindly action of
15 or 50?
15.
Yes.
15.
Lordship, may kindly action for the Lordship.
You want an adjournment?
Lordship.
Okay, but it goes for 2 weeks.
Obliged.
Okay, 15.
May I please, item number 33,
Yes.
seeking adjournment.
33. Okay, same order. 2
All
weeks.
May I please? Item number 43, Lordship.
43, somebody has already mentioned.
Sorry, Lordship. 42.
Yes.
Only adjourn for 2 weeks, Lordship.
42, you're sure?
Yes, Lordship. Anwara Khatun.
Okay. 2 weeks.
May please, Lordship. Item number 23, my Lord. Kindly may adjournment for 2 weeks, my Lord. 23.
23.
My Lord.
Okay, same.
Obliged, my Lord.
May please, your lordship. So I beg to mention item number 19, lordship. Early adjourn for 2 weeks.
19.
Yes, lord.
Okay.
Item number 21 and 41, my Lord. This can just maybe taken next week, my Lord.
21 and 41.
21 and 41.
Okay, same order.
Obliged. May I please your lordship. Lordship, item number 1, I beg to mention for adjournment. Pass over for the day.
Item one, you should always wait for your turn. Never
Friday.
mention item one.
Item number 1
Okay.
on Friday.
Item 1, Friday. Obliged, lordship.
Friday will be 8th.
But I will mention item.
No,
number-
Friday will be 9th. No. Friday is 9th.
Yeah, I would like to mention item number 16.
16.
Let the matter may come after 4 weeks.
After 4 weeks. Why?
Actually, due to shifting by chamber, record is misplaced. Only the ground is.
Okay, 4 weeks. Much big.
Maybe this question, I beg to mention item number 28 may be adjourned.
Item
28. Senior is out of station.
28. Okay.
Obliged.
Lord, the similar ground, my lord, I have desperate medical emergency, my lord. Item 39, I am praying for adjournment of this matter for 2 weeks, my lord.
39.
39.
32. Okay.
Did you have-
May it please lordship. Lordship, I beg to mention one WPC for listing.
For
For
listing. It to the province.
Please, your lordship, I beg to mention item number 21. Kindly fix the matter after 1 week.
21, somebody has already
20.
taken an adjournment. 29. Okay. Same.
My lord, this matter, my lord, was listed on 26/3/2025. And it was not registered on that day, my lord. May I claim, my lord, it may be listed on Friday, my lord. Obliged, my lord.
Daily list item 2 for motion.
You got these
Lordship,
records?
This matter will require some time, lordship, so lordship may fix it up for admission hearing. Notice has been issued, he's already on bail, lordship. And lordship had kept the issue of delay and maintainability open, lordship, on this, so.
This is the record that you had, it is produced at your instance. In the
nobody
last-
has come till now, lordship, I'll need assistance of my,
In fact, by order dated 22/4, we have requested you to call for the records of FT case number 789 of 2015.
yes, lordship.
So this is it. It's here. You've gone through it? No.
No, I have not, because nobody has come, my
Okay.
colleagues have not come till now, lordship.
You went on Friday.
Not this Friday, lordship, next week.
My lord, I may kindly be protected.
I think lordship bail was.
No, bail was not granted.
Lordship, next week, anytime, lordship.
This is opinion of, it's not a delay,
18.
16/5/24 opinion. We grant bail to the petitioner.
Opinion dated is
16/5/24.
Shah Jahan. Oh, lordship, I'm looking at a different, I'm looking at a number 2 to my different. Sorry, lordship,
No,
I'm
it's okay.
looking at a
Okay.
different record,
No, it's
lordship.
okay. You can see this.
Yes, lordship, it
Yes.
is side one. Dada, item 2. Item 2. I'm not sure my item 2. Sorry, sir. You give a Alexa as a look. Nay.
This is Verma, page 77 is the record. 16/5/24.
77. Lordship, bail may be granted, lordship.
But just check the first, last order. This record has come, I was just wondering. I did not see the office note. First order is that you were directed, third paragraph.
Accordingly, we request the learned to obtain the said records to produce before the court.
But this record has come. Kindly check the office note. I have not checked.
LCR has been received, Lordship. It
Oh,
will-
otherwise also received. Okay.
Yes.
Okay. Mr. Ivy Mahmood, done counsel for the petitioner. Respondents are there. Mr. Islam on behalf of AIRD.
It has been received, yet it received 24.
Next person to. The records of the tribunal, as called for, is received
On 24/4/2025.
on 24/4/2025. The learned standing counsel for the FT matters. Pays for a short adjournment so as to enable her to peruse the records and make her submissions. Next paragraph, the learned counsel for the petitioner has prayed for bail, which is opposed by the learned standing counsel for the FT matters. Next paragraph, considering the projection made in this writ petition, the court is inclined to grant bail to the petitioner, namely counsel. 10 days time to take bail. Rupees 5,000 to the satisfaction of
SP Naga.
SP Nagaon. Mr. Mahmood, please check up whether your the district commissioner is the appropriate party or not. Just check up, because who is the whether deputy commissioner or district commissioner, who is the party?
I think he is a party one.
Hmm?
Stated by the commissioner secretary. Coordinator, district commissioner, my lord, 5.
District commissioner.
Yes.
Okay.
Respondent number 5.
Okay, that's okay. You want additional copies for you?
Yes, Lordship.
Okay. Before this, you say, each notice written about on
की NRC কপি লাগিব না? আমি তো ঘৰত লৈ নাযাওঁ।
16/5/2025. Requisite extra copies of the petition be served on the learned CGC, State and Department Council within 2 days. Then prayer for bail. List on 16/5/2025. 16/5 we are listing.
Yes, Lordship.
Hello, let's go.
Excellent.
Item 3 for motion.
Yes, Mr. Dev. Which page is the opinion?
My lord,
2019, you are challenging now.
my lord, I have explained in the paragraph 39, 40, 41, my lord. The petitioner,
9/40/41.
my lord.
Lordship may call for the LCR and interim.
LCR has come. LCR has come.
Just come, Lordship.
You go through it. Will
But here it doesn't show the cause list doesn't.
no, it's
show.
okay. But it has come.
My lord, here is the question, my lord. Petitioner has given a doubted as a foreigner, my lord. Kindly see, my lord, the LBO report. LBO report, my lord, page 106. 109, my lord. Here, my lord, the petitioner address name is given Falaton Nesa, address D. Goduni, father's husband's name Kayad, date of birth, place of birth D. Goduni, Dokhin Goduni. That is in Dobri, my lord. Borbetta, in Borbetta, my lord. So he was born in Borbetta. And the entire, my lord, Annexure A, that is Ralbio report, is blank. So if a person is not doubted to be a foreigner, my lord, whether reference can be made, kindly see the ERO report, my lord, page.
No, we have seen that, but you see what has happened here. Based on that, the Superintendent of Police says that Annexure B of the ERO considered as a ground for considering the person is illegal migrant. So once that satisfaction is recorded, we can't help it, because ultimately the referring authority is the Superintendent of Police.
My lord,
Who has recorded his
LBO report is said that, my lord, the place of birth D. Godoni, that is Dokhin Godoni in Borbetta.
Correct.
And he has not been suspected as a foreigner. Entire reference is, my lord,
That's
report
okay,
is
but
blank.
once
And my lord, kindly see another interesting thing, my lord, annex page P17, page 108, annexure P17. This is the report of ERO, my lord.
yes,
ERO
seen that.
report, kindly see the date, my lord, dated 15/11/1995. And kindly see the first paragraph, where the Election Commission of India has ordered intensive release of electoral roll of for the year assembly constituency, a type copy, my lord, reference to 1197 as the following qualifying date. My lord, I am reading the typing copy, page 107. Whereas house to house enumeration was done during the period of 16th January 1997 to 15th April 1997. So it is seen that 1997 enumeration was done, but the reference was made, report was given on 15/11/1995. This is an absolutely non-application of mind, my lord. And kindly see the doubt, where from doubt, paragraph 5. Whereas the electoral registration officer for said assembly constituency having doubt about the citizenship of the said person got the matter verified by on the spot local verification, and whereas on consideration of the report of such verification, I have reasonable doubt.
Mr. Dey, that becomes a part of merit. But how do you explain the delay, first of all,
My lord,
2019 to 25?
In Abdul Rahim case, my lord, and as well as the Anjana Vishwas case, and details, my lord, judgment has been given, my lord, in this regard, my lord.
Okay.
Whether persons not doubted to be a foreigner can be made a reference to the
No,
foreigners tribunal for
that is on merit.
determination.
That is on merit.
My
But
lord.
how about the delay? First, what has
Total,
is
my
it delay?
lord, my humble submission before your lordship is that it is, this reference has been absolutely total non-application of mind, my lord.
That may be a good ground on merit, but to
Delay, my lord, kindly see the 30 page 39, paragraph 39 of my petition. 39, 40, 41, paragraph 39, page 23, my lord. My lord, judgment was passed on, my lord, 27/1/2020. And they issued the authority on a certified copy was issued on 13/2/2020. Thereafter, the COVID pandemic occurred, leading to the nationwide lockdown with which was extended periodically and continued in various phases till the year 2021. During that time, the petitioner's family incurred huge financial losses and also struggling to make the ends meet. The petitioner, who is also an old woman, was not in a mentally and financially sound position to take necessary steps to assail the impugned order before this honorable court. Thereafter, during the middle of the year 2022, the petitioner started get mild symptoms of hemiparesis in the form of bodily weakness. The same got aggravated, leading to the partial paralysis of the left side of the body, and the petitioner had to undergo treatment for the same in Satla PHC Borbetta with effect from 27/12/2022 to November 2024. It is pertinent to mention herein that the petitioner's husband, being an old aged person who is suffering from various ailments, was not in a position to come to Guwahati for doing the needful to challenging the impugned opinion passed by the learned foreigners tribunal. Her only son, Faizul Haq, who is a daily laborer, was taking care of her and also could not take any steps due to their suffering and poor financial condition. It is only after she partially recovered from her illness, she somehow sent her son Faizul Haq to Guwahati on 2024 to engage an advocate for approaching this honorable court, assailing the impugned order dated 4/12/2019. Faizul Haq met with his advocate on 20/12/2024, and his advocate, after going through the same, advised him to bring some important documents which were not in the file. Faizul Haq thereafter returned and obtained some certificate copy from the Foreigners Tribunal and came back to Guwahati on 21/2/2025. And his engaged lawyer took some time to prepare the petition and accordingly filed it in the earliest opportunity. Under such circumstances, it is humbly submitted that there is some delay on the part of the petitioner, which was not at all intentional, and as such, this honorable court may kindly condone the delay for the interest of justice. Petitioner stated that her fundamental rights are involved in this case, and the claim made in the writ petition is legally sustainable, and as such, the aforementioned delay may be condoned to promote the substantial justice. Paragraph 40, my lord. The petitioner begs to submit that the basic concept of law to provide justice to the aggrieved and not to deprive him from proper and fair administration of justice. It would cause great prejudice and irreparable loss and injury to the petitioner if this honorable court does not interfere with the impugned order dated 4/12/2019 of the Learned Foreigners Tribunal because of delay. The petitioner begs to state that the impugned order dated 4/12/2019 passed in the FT case number so-and-so not only deprived the fundamental rights of the petitioner, but also has the potential to throw out her from her native land, despite of the fact that she is a citizen of India by birth, and as such, the impugned order is liable to be set aside and quashed for the interest of justice. So, my lord, I have annexed some medical certificates also, a prescriptions and the certificates, the last series. Certificate is 117. This is issued by the doctor, my lord, Tapla PhD, Borpeta. So, my lord, my humble submission, since the fundamental rights is involved of the petitioner, my lord, the delay so caused, my lord, is not at all intentional. The circumstances compelled her to delay, not to come in time, my lord. So that may be condoned, my lord. The case may be heard on merit. Condonation also. Tukaram Thana Joshi.
Mr. Dey,
My lord.
for the purpose of bail, you'll have to show us more documents of medical to show that she is suffering from hemiparesis. You see, what happens is that hemiparesis otherwise can't be diagnosed without a brain CT scan or a MRI scan. It's just not diagnosed, cannot be diagnosed. So therefore, for somebody to say, a doctor to say that a patient has suffered from hemiparesis, must have some supporting document to give that finding. Because it is just not possible to look at someone and then give a diagnosis of hemiparesis. Hemiparesis leads to a paralysis of one side.
One second.
So for that, there must be a corresponding, what you call, sign in the brain. Otherwise, it just can't happen.
Otherwise, my lord, I have one judgment, my lord,
Pass it on.
right,
Please pass it on.
regarding condonation of delay.
Pass it on.
Tokaram Kana Joshi, my lord. Paragraph 10, 11, and 12, my lord. Paragraph 10, my lord. The state, especially a welfare state which is governed by the rule of law, cannot arrogate itself to a status beyond one that is provided by the Constitution. Our Constitution is an organic and flexible one. Delay and laches is adopted as a mode of discretion to decline exercise of jurisdiction to grant itself. There is another facet. The court is required to exercise judicial discretion. The said discretion is dependent on facts and circumstances of the cases. Delay and laches is one of the facets to deny exercise of discretion. It is not an absolute impediment. There can be mitigating factors continuing the cause of action, etc. That part, if whole thing shocks the judicial conscience, then the court should exercise the discretion more so when no third-party interest is involved. Thus, analyzed, the petition is not hit by doctrine of delay and laches as the
So this may not be wholly applicable in your case. The reason is that you are citing us the Tukaram Kana Joshi.
My lord.
Tukaram Kana Joshi is a case where a land was acquired without due process of law, and therefore the Supreme Court says that Article 300A is infringed. And it also says that the deprivation of property must be with sanction of law. And therefore it has referred to the 2 or 3 judgments on that account. But here is a case
My-
where once a person is declared to be a foreigner, the interest of the state is there to remove him from the country. So a foreigner cannot be allowed to stay in the country without due process of law, and that process has been thwarted just because of delay. You see today also when this petition is filed, the signature in the affidavit is by her son. So this position was there even 6 years back.
My lord, my humble submission is that, my lord,
It's not a case that
For the-
he or she
for the
got
in-
well.
for the interest of substantial justice, my lord, petitioner citizenship is concerned, my lord, here. It is serious,
No, but
my lord.
she accepted that judgment for 6
So
years.
the fundamental rights of the petitioner is involved.
He has
so-
accepted the judgment for 6 years.
Substantial justice, my lord, this delay may be condoned, my lord. And the case may be heard on merit. My lord, that is my
Unless we
humble-
can give you a week's time to get us more document of medical to show that she has been diagnosed of hemiparesis. Merely noting in the prescription that she has hemiparesis does not inspire confidence.
My lord, I am
I
citing.
can tell you, I have this what you call a preliminary idea of a hemiparesis.
My lord, this certificate has been given, my lord, that is, actually, my lord, I have
Yes.
no idea the medical regarding.
I can tell
medical.
you, not at the court's time, but if you come into my chamber, I'll tell you what is hemiparesis is. During my lunchtime, I will spend some time and tell you what hemiparesis is. But the fact is that the a mere prescription saying that she has hemiparesis does not inspire confidence. There must be something more. One has to have it to say, because you see, it's not a case. A doctor can just see a person and then diagnose a hemiparesis. It's just not possible. Lunchtime you can come in, I'll tell you why.
My lord, Paragraph
can give you
12, my
one-
lord, in this petition.
can give
says
you
that
1 week's
for
time.
cause of substantial justice, my lord, the delay may be condoned. Otherwise, third party is not no way, my lord, in
State interest is of
in-
greater interest.
because third party is not, my lord,
No, state's interest
no
is a
way
greater interest.
affected, my lord.
State's interest is a greater interest.
State interest, my lord, if
State
the
interest will be
citizenship
paramount
is
than a
decided
third-party
and
interest.
by this honorable court,
We are
my
not-
lord, state is not no way affected, my lord.
Yes, it is.
No way affected, my lord. That is my,
Yes,
my
no,
lord,
I can
for the
give-
ends of justice,
I
my
can
lord.
give you a chance of a week's time. You produce the medical documents to support it, because otherwise we'll have to dismiss it. We can give you some time, 7 days, 10 days time to get some document to show the diagnosis of hemiparesis. If you can show the diagnosis, then there's a fair chance.
Otherwise, also, my lord, there is at the corona period, 2 years gone, my lord, for this way or that way, my lord, that period is, my lord, maybe considered, my
We
lord.
have answers for all that, but we just want to give you an opportunity just to show us some medical documents to show diagnosis of hemiparesis. If that can be shown, we will give you a fair chance, but not on the basis of this.
Petitioner is aged about 65 years, my lord. She's the lady, my lord.
Can't be helped.
65 years, my lord.
You either take the opportunity or leave the opportunity.
Only-
Some diagnosis of hemiparesis must be there. There must be some basis to diagnose hemiparesis.
Let us come after 2 weeks, my lord. 2 weeks.
Mr. P.C. Dale and counsel for the petitioner. All the respondents are represented. Next para, the learned counsel for the petitioner has referred to the medical documents, medical prescriptions to project that the petitioner was suffering from hemiparesis, Hemiperesis, hemiparesis, Peresis. Just check the spelling, hemiparesis. However, there is no document showing how the said disease were diagnosed. Stop. Accordingly, the learned counsel, next para, accordingly, the learned counsel for the petitioner prays for and granted 2 weeks time to supplement, to produce any document, medical document showing how the said disease were diagnosed. On what basis did said disease were diagnosed? Stop. List on when.
After 2 weeks,
Give a date after 2 weeks.
21 May. 21 first.
Item 4,
Yours. My lord, on the last occasion, LCR was called for, and LCR is here. Notice was never served to the petitioner, my lord. And that is also reflected in the notice server's report. That is Annex 21.
Last decided population. Document EMI did not produce any documents. Persons and the non-debt profit. Sounds in random person schools. The classic. What will I will do? Okay, so you need to see. The problem. Não vai ser não.
You have the certified copy of this Jamabandi and the land document? Annexure 15, do you have a copy, readable copy?
Document 15 my lord, original is there, my lord.
Page 54, 55. The certified copy, do you have it?
My lord.
And page 57 onwards,
Yes.
it shows that.
Okay.
because this, I can't read page 57. 57, the date of registration is 8/4/85, I think,
83, my lord,
83.
my lord.
So this is a post reference document.
Post, my lord.
You can just pass it on.
And the certified Jamabandi, that is for the year 2016, 1960, my lord. It was a guilt position. 60, 1960, and gifted in 1963. Gift deed is also there, my lord, which was executed in the year 8/11/1983.
All other documents are post.
Yes, my lord, fourth. No, lord, it is certified copy that is prepared in 1960, my lord. And collected those certified copy
Order dated 6.
in 2025.
Page 58.
And the original, my lord, gift deed. Answer 15. Certified copy of Jamabandi, my lord, second page, bottom, date of record correction 26/11.
Just a moment, we are looking at something. Just a moment.
Yes, yes. Yes, Lordship.
As per the report, he has no landed property and therefore it was served on the, it was pasted in a masjid,
Yes, Lordship.
correct? Now he's producing documents to show that he has land in that area.
Yes,
The only problem we are facing is residence as per the notice of the tribunal is
Poschim Singulia.
Poschim Chengelia. Now, in the cost title, he has given the address as Chengelia only. And the police station is different. Now it is Barpeta and earlier it was Sorbog.
Yes, Lordship.
It is showing us land documents.
Yes, Lordship.
It is in Chengelia. So if this is correct, then the Gambara certificate would be wrong. Page 15 of the LCR is that Gambara certificate.
Not.
It will, Raji. जी.
Lordship. See, Abdul Hasim. Hasim হবে, not Abdul Hasim. Attempt to prove his case, Lordship. Possible. All these things are, Lordship, matters of factual determination, Lordship. And hello, তাতে কও। একদম তাহলে বলে গ্রুপে নাই গো।
Dewan.
তো বউ মারিব। আব্দুল পশ্চিম এমনি সাহেদ আলী আর সাহেদ আলী একে তাই না Land document to print over the land document to land document to consider the land document. Actually, my lord, present petitioner and the proceedee, entire identity is separate. Petitioner before your lordship is the Hashem Ali and the reference proceeded against the person Muhammad Abdul Hashim, and father's name also not tell you with the original Shahed Ali, and in the tribunal it is Syed Ali. All things are different. That is why maybe and that person was not found. And presently searching the petitioner for arresting. All the documents are one passport also issued before in favor of the petitioner, my lord, in 2014.
Mr. Sharma, I think he has a reasonable explanation.
Lord.
But that is why we are not finding the name tallying.
Lord,
Mr. Ahmed is saying that the identity of the proceedee is different from that of the petitioner.
Lord,
Because you,
maybe my lord, but
so
all
the,
this,
the tribunal will examine the
yes, this helps.
identity.
Okay.
If
Otherwise,
it's not telling.
okay. Yes, tribunal is the appropriate from lordship, and lordship let him go and prove that
It's
he is
not
the
the
son of
proceedee.
Sahed Ali, whose name appeared in the voter list of 1960.
No. He says that he is not the proceedee at all. The proceedee is someone else. Similarity of name. Because we did not get it earlier. The name of the petitioner is similar to that of the proceedee.
Hmm.
His father's name is slightly different. Perhaps that is why the records are not telling. Police is now searching for him. So that is why this police station Sorvog or police station Borpeta.
and my lord, inquiry board also, father's name is once wrote as Amjad Ali, and on the next page it is written as Said Ali.
Good.
Page 76, my lord. 76 and 77.
76, 77.
Type copy as at page, my lord, 71 and 73.
No, 76, 77 is better.
Yes, my lord.
76,
76, father's name late Amjad Ali.
yes.
And again written as
Only one, that page 76 is only there.
my lord,
Amjad Ali.
Amjad Ali.
Mr. Sharma, just send back the records. Let me examine it.
Lord.
Please send the records.
Sir,
We'll send it back. Let the records be examined by the tribunal. We'll permit him to appear. But Mr. K.U. Ahmed, land counsel for the petitioner. Also heard all the respondents are there. Ms. Pedi on behalf of Ms. P. Barua. Next one. By filing this writ petition under Article 226 of the Constitution of India, or the petitioner has assailed the ex parte opinion dated 25/7/2019, past page 62, as based on insurance. P number so and so, declaring the petitioner to be a ex parte opinion, to be a post 1971 migrant, illegal migrant. Next question. Pursuant to the order dated 11/4/2025, the relevant records from the tribunal has been received. Next paragraph. The learned counsel for the petitioner has submitted that as per the process service report, no notice was served on the petitioner. However, notice was pasted in the local masjid. Next paragraph. Moreover, it is submitted that as per Form 1, Roman 1, by the inquiry officer, the inquiry was made against Muhammad MD, Abdul ABDUL, Hasim HASIM, son of late Amjad AMZED, Amjad Ali. You please examine the records and then address us. We'll take it up some other day on Friday.
Lord,
Now, what we see while we are dictating the order, as per form number 1, which was that page? Form number 1 is at which page?
71, my lord.
71. No, show the original one.
Original, my lord, page 76.
76. Now you see, this is an inquiry made in the year 2000.
yes, Lord.
This man is Abdul Hashim, is 45 years. His name of the spouse is Jawra Khatun.
Lordship.
Correct. Her age is 34 years. Now, from the documents annexed in the writ petition, please come to page 41. It's electoral roll of 2005. So we are 5 years down the inquiry.
Hmm.
Next
Yes.
page 42 is the petitioner, Hashim Ali,
Similarly,
52. So 2 years age gap.
yes, Lord.
Then spouse name is Jawra Khatun.
Geographer, yes, yes,
Age is 39 years,
yes, Lord.
less by 3 or 4 years. But it matches,
Yes, Lord.
except for
Matches.
spelling, even the name of the spouse matches.
Yes, yes,
Please go through it and address us.
Lord.
Father's name is not tally with the report.
No, may not be, because in the all other reports, your name of your father is Syed Ali. Except for this LVO report, the SP report and all, everything is Syed Ali.
Land document Shahid Ali.
But that's okay, except for that Amjad Ali in the form 1, everything all matches.
Yes, Lord.
Because it may be a case that after post inquiry, this inquiry was made in 2000.
And all the certified copies are obtained in the year of 2000.
No, whatever, that's why we are asking you to go through it and then address us. Take it up on Friday.
Lord.
You just go through the records. Just say also as a representative. As the record of the concerned tribunal is received. Comma. We are inclined to request the Direct Standing Council for the FT matters to go to the LCR and address us. Address the court. Next list on Friday. 8/5/2025.
9/5 Friday.
9/5. Okay.
My lord, it
We
may
are
be
in
8,
your
my lord.
documents.
It may be 8, my lord. 8
Pardon-
5
Pardon me?
Friday.
on Thursday, my lord.
9/9. Because we have special benches on these days.
I'll share to Sabo. Will do.
We'll give to you, just note there. Accordingly, the records of the tribunal are handed over to Mr. G. Sharma and the standing counsel for the FT matters. After that, will be list on so and so. Yes. It will come up.
Obliged.
Yes, item 5.
May I please know?
Yes.
Lordship, this is related to FT matter in FT case number 1/2017. The reference made by the SP.
So please speak loudly. We're not getting a voice.
On the mic.
Lordship, there is an interim prayer for bail, Lordship.
Which is the best document you have to connect you to your projected parents? Apart from voter list, don't show us the voter list. Any document except voter list to connect you to your projected parents?
Lordship, impugn order.
লিঙ্ক ডকুমেন্টের কথাও কিছু লিঙ্ক ডকুমেন্ট এখন না
Lordship, the petitioner casted his vote in 1989. Lordship, may peruse page 33.
You see, we are only referring to the voter list. Except for 1989, you have no other voter list with your family. Next voter list, you are out of the family. In 1977, you are out of the family.
Lordship,
So we don't have your connection except for that voter list. In 1989, you were shown as 28. Therefore, there should have been any other voter list except for 89.
Bye.
That's why we asked you, except for voter list, do you have any other document to connect you to your parents?
আমার কেস এই বয়সর আপনি প্রফেসর
We are not getting your connect. We are not getting your connect.
Lordship, I have cited some of the judgment.
Judgment without documents, without satisfying us with the judgment, what documents, what will the judgment do? You come to page 46. We appear to be more prepared than you. Come to page 46.
Lordship.
Come to paragraph 11. The name of the father, stepmother, so and so, so and so, so and so, appeared in so and so. Correct.
Lordship.
Now come to page 34. This is 1997. Your name is not there.
Lordship.
Then only for a single voter list you appear with the family. Where were you all throughout? Then you say, after this, after 11 in paragraph 12, you say that this in 1997, your elder brothers, this is the elder brothers voter list. And then in paragraph 13, you say that you ask for a certified copy of voter list, you are not getting your copy. And the last voter list you are showing us is page 34, 35. Your brothers, elder brothers voter list is not here. And then your own voter list, you can't show from the from these serial team of voters that you had a name there. Your statement is without documents. Now let us see what judgment you want to show.
Give me peruse page 16.
Page 16.
Yeah. State of Assam and others versus Muhammad versus Muslim Mandal and other reported in 2013-1 GLT 809,
Yes.
also held in para 98. The reference by the referral authority also cannot be mechanical. The referral authority has to apply his mind on the material collected by the investigation officer during investigation and make reference on being satisfied that there are grounds for making such reference. The referral authority, however, need not pass a detailed order recording his satisfaction. An order agreeing with investigation would suffice. The referral authority also, while making the reference, shall produce all the materials collected during investigation before the tribunal, as the tribunal is required prima facie to satisfy itself about existence of the
Where is the verification report in your writ petition? Is it annexed? That verification report you are referring to from Muslim Mandal judgment, is it annexed in your writ petition? It's not annexed. Correct. It's not annexed. Right or wrong? It is annexed. Not annexed. Okay. No, please tell it, because this is something I can't understand. If I travel to south, this will be yes. So we don't know. Please tell us. We are asking you a question. Three times we are asking you a question. Please reply. Not this or that. There is something I don't understand. Now, second is, before you start before you begin your submissions and showed us the Supreme Court judgment or the High Court judgment in Muslim Mandal case, did you take the trouble of looking at the records? The tribunal records were there. Did you spend time to look into it? No. Yes or no? Did you read the file? Did you go through the file? Yes or no? Please don't say it. Don't shake your head. It can mean anything. I have very close friends who say yes like this. I have very bosom friends. Tell me yes or no. Did you read this or did not read this? No. So you see that's the big mistake you did. When you are when we are examining a record of the tribunal and you don't care to look into it, you make a wrong submission. This is not a LVO report. This was a ERO reference. So the Muslim Mandal will not be applicable. Muslim Mandal never dealt with ERO reports. Anything else you want to cite before us? You should always understand, with this record, we are asking you just one question of 1997, 1989. We referred to two voters list. We did not ask you anything else. Any other judgment you want to cite before us? No. Then we close the matter. We'll pass orders later on. We'll examine and pass orders in the chambers. You have to say anything more, Mr. Sharma?
Lordship, Welfare's opinion, Lordship. There is no infirmity in the opinion, Lordship.
You're saying so because I said so, or otherwise you have any material to say that it's not sustainable?
No, Lordship.
It's sustainable.
Moral statement, nothing is there, Lordship. No link document is there, Lordship.
In your, did you read your written statement? We are asking you a question from there. Have you read it? Yes. Now please tell me, in your written statement, have you made a statement that you live in a different household from that of your parents or other members of the family? Is it a stand you have taken in your written statement? Mr. Sharma, just read it. Well, I did not find it,
Lordship.
but I did not read it thoroughly. I just scanned it and as you said anywhere that that he resided separately with his other members of the family. The written statement is at page
No, my lord.
36. That's the written statement.
Yes.
Custody grants, we did not find it. That's why we are asking you.
No, Lordship.
No, it's not there.
Right.
Mr. Sharma, we just tell you, we've gone through the trial court record of the tribunal. In 1997 voter list, he is in house number 60. There are two names in house number 60, but we don't know whose names there are. And in house number 70, the other members of the family are. That's why we are asking only one question in the voters list. Has he made any statement that they are residing in a different household? It's not there in the pleadings.
Yes, Lordship.
And even if he resided in a different household, then also the record of the tribunal was not called for. We have shown you the written statement where he says that I did not get a certified copy of my voter list.
Yes, Lordship.
Whether it is right or wrong, we don't know. In the trial court record, against his name in pen, it is written DN.
Lordship.
But what is DN, we don't know. Just check.
Doubtful national, Lord.
Doubtful-
DN.
DN. Doubtful
national.
national.
Yes.
Okay. So that entry is there.
Yes.
But he could have called for the original and then have it verified when the name is there in the voter list. That could have been done. That was not done. So there is an evidence which is lost. And therefore there is no connect.
Yes. No.
Okay, we'll pass orders in chambers.
Otherwise,
If we can't dictate the order today, then we make it sealed.
he is getting ample scope to prove his case before the tribunal, Lordship.
No, getting a scope and knowing how to prove it are two different things is the problem. If for some reason we can't complete the dictation today,
No.
then we'll make it CAV. Your name?
A Thakuria.
A Thakuria. Okay. Next time, please remember, we are not calling for the trial court record just for nothing.
Highly obliged.
Item 6, or rather just a moment, we'll take a short break and come back. Just a moment, we'll take a short break and come back.
Item 6.
Lordship, Commissioner declared for an ex parte lordship wide order lordship dated 24/6/2024.
How many adjournments you took for
Lordship,
written statement?
4 or 5 adjournment I have put. Page 31 starts from, in order page starts from page 31 and page 32 lordship, second paragraph in detail mention lordship. Actually, person is different lordship, name and address are different lordship.
You have taken a lot of adjournments, but
Lordship. On 3 occasions I have taken, and 2 occasions I have not appeared, my counsel also not appeared.
21/7/23,
Lordship.
5/7/23, then 21/7 you were absent. Then 14/8/23,
3/10/23,
3/10/23,
6/11/23.
16/11/23, 7/12/23, 8/1/24,
Without states loss.
whatever be, but the matter was adjourned.
Loss.
19/2/24, 16/3/24. Sixteen, 4/24. 29/5/24. 11/6/24. This makes your statement a false statement. I've asked you a question, how many adjournments you took? You said 4 or 5. You are giving a false statement before the court.
No, not intentional loss.
I don't know. It's not question of intentional or not intentional. We ask you a specific question. And then we had to calculate.
Loss.
Now in calculation, it is more than 5.
I apologize.
It's nothing. You lose your credibility. It's nothing for us.
I apologize, loss.
We are looking at it, but you lose your credibility. You will find that when we hear some lawyers, we don't check the records. We take it by on face value. That's something you will miss. then you don't have a chance. We can't interfere with your with the opinion. You see, come to page 36 onwards.
My lord.
You have produced the certified copy of the certain voters list of 1966 onwards.
Yes, my lord.
You omit page 36, come to page 37. This certified copy was obtained on 23/7/2018.
Lordship.
Next certified copy is obtained on 23/7/2018. Third certified copy is
Before-
obtained on 23/7/18. Fourth is same day.
Almost same day, lordship.
No, one is different.
On 110
Fifth is same. Sixth is same.
9, no, annexure 9 is 10/7.
Seventh is 10/7. Oh, this is different. 10/7, 10/7, 10/7, 2019.
Lordship.
So why did you take, why did you remain absent on take an adjournment on 12 occasions for filing a written statement? There is no additional document filed here in this writ petition to even demonstrate that on the day when you took adjournments, you did not have copies. All these certified copies were available with you.
Copies were available, lordship.
Then
Lordship, some instruction, lordship, there was communication gap, lordship. He lost communication with the lawyers, lordship. And lordship,
communication gap means that you went to your lawyer's chamber and lawyer did not speak to you. How did the communication gap occur? You went to the chamber of the counsel and counsel did not speak to you? What is the explanation?
lordship, actually, he lost communication. Otherwise, lordship, the petitioner is also lordship defined person, lordship, on the, but whatever, but he has since accepted notice, lordship.
Breaching is still lordship. No
Only-
different person lordship.
Huh?
On what basis you are saying that?
Lordship, may kindly see the notice, lordship, case 28 onwards, lordship.
Page 28.
Yes, ma'am. Here petitioner's name, here the proceedings name is Sahinur Islam, lordship. Whereas my name is Shahanur Ali, lordship.
Oh, please read your cost title at page 4.
I have mentioned alias because the impugn order is in.
Then we can't help it.
And lordship, may kindly see the.
No,
ID
you
card,
see,
lordship.
what we look is that what we will read is from page 1 onwards of the writ petition. And we have read up to page 4. Shahanur Ali Shahanur Islam. And that is an admission, number 1. Now please come to page 27.
My lord.
What is the name?
Still name is Shahanur Ali, but.
Alias Shahanur Islam. And this is sworn by an affidavit.
Lordship. What is lordship documents annexed, lordship, may
We
kindly-
don't know. I personally am not acquainted with this petitioner.
And I have taken plea that I am not the person, village is also defined, lordship. Only father's name is similar, lordship. In your lordship, he, since he not accept notice, lordship, he has to prove, lordship, that I understand, lordship.
Once you appear before the tribunal, then you don't file it within time. Your explanation is incorrect or not acceptable. All the certified copies are pre-appearance.
Documents were available, lordship.
Now, please tell me, I ask you one last question. This notice you referred to at page 28
Yes.
is dated 19/5/23. Correct?
Yes.
Now, when the notice issued to you is on 19/5/23,
Madam.
what was the reason for you to have certified copies of the voters list taken prior to even a notice being received? That means that after the LBO made an inquiry, only thereafter the doubt of your nationality was expressed in 2007. Only thereafter you got these documents and you are ready.
That may be lost, but may not be also lost.
Otherwise, why will somebody have a certified copy of voters list? I ask myself, I don't get an answer. Why will somebody take trouble of getting certified copy of voter list just out of the blue?
Maybe some for other purpose also lost.
Okay.
I don't know. Lost.
So document obtained for some other purpose cannot be used for filing written statement.
Since it is certified loss.
Oh, yeah, sorry. But Mr. J. Abbas, Land Counsel for the petitioner. Also, all the respondents are there. Ms. Bedi on behalf of SP Barwa. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the ex parte opinion dated 24/6/2024, passed by the learned member, Foreigners Tribunal number 1st of Dhubri in FT case number. This will be at page
31 loss.
31. Next paragraph. The learned counsel for the petitioner has referred to the statements made in the writ petition, and it is submitted that there was a communication gap with his engaged counsel, and therefore written statement could not be filed within time. So it is also projected that the petitioner is an illiterate person, but he has several documents to establish that he is not a foreigner but an Indian citizen. In this regard, it is projected that the name of the grandfather of the petitioner appeared in the electoral roll of 1966 of village Chagolchara, CHAGOLCHARA, Art Roman 1, under number 33, Dhubri LAC. Grandfather and grandmother. Grandfather and grandmother. And their names also appeared in the electoral roll of 1970. The name of the father and grandfather of the petitioner appeared in the electoral roll of 1975. And the name of his parents appeared in the electoral roll of 1979, 1989. And in the electoral roll of 1997, name of his parents appeared along with two brothers of the petitioner. And the name of the petitioner appeared in the electoral roll of 2005, along with his parents, three brothers and sister-in-laws. And that in the electoral roll of 2011, the name of the petitioner appeared along with his brothers and sister-in-laws. 2011 and 2018. Next, by the learned counsel for the petitioner has submitted that the petitioner is a resident of Chagolchara, Chagol, Part 1, and is not a resident of village Adawari, Part 1, ADA-BARI. The learned counsel for the petitioner has also submitted that the name of the petitioner is Sahanur, Sahanur, Sahanur Ali, but the reference against the petitioner, reference was made against one Shahanur, Sahinur, Sahinur Islam. Accordingly, it is submitted that the petitioner, being a person from an economically weaker section of the society, given an opportunity to contest the proceeding by filing his written statement. Next one. The prayer is opposed by the learned standing counsel for the FT matters. Next one. Consider the materials available on record. Next part is seen that the learned tribunal had issued a notice dated 19/5/2023 to the petitioner to appear and contest the proceedings, fixing the next date of appearance on 5/7/2023. As per the contents of the impugn opinion, the petitioner appeared along with his engaged counsel on 5/7/2023 and prayed for time, which was allowed. On behalf of the petitioner, prayer for adjournments were made on 21/7/2023, 14/8/2023, 3/10/2023, 16/11/2023, 7/12/2023, 8/1/2024, 19/2/2024, 16/3/2024, 29/5/2024, full stop. However, it is seen that the petitioner as well as his learned counsel remained absent when the proceedings was taken up on 16/4/2024 and 11/6/2024. Only thereafter, the ex parte opinion was passed on 24/6/2024. Stop, therefore, therefore adjournment was made and allowed on 10 occasions, and on 2 occasions the petitioner remained unrepresented. Stop. Petitioner appears to be unrepresented when the opinion dated 24/6/2024 was passed. Next paragraph. Although the learned counsel for the petitioner has submitted that the petitioner is a person from weaker section of the society, illiterate, and therefore requires an opportunity to contest the proceedings, but we notice that in the present rate petition, the petitioner has annexed photocopy of the certified copy of electoral roll of 1996, 1970, 1975, 1979, 1989, 1997, full stop. The certified copies are found to have been issued on 23/7/2018. Moreover, the petition has also annexed photocopy of the certified copy of electoral roll of 2005, 2011, and 2018, and the certified copies thereof was issued on 10/7/2019. Full stop. Therefore, all the documents that the petitioner has annexed to this writ petition appear to have been procured much prior to the issuance of notice to the petitioner of commencement of trial against him. Strong. Thus, comma, it is not a case of the petitioner that he could not procure any document for which written statement could not be held on time. Next paragraph. In this writ petition, it is projected that there was a communication gap between the petitioner and his learned counsel, which is not acceptable because the petitioner has not referred to his own conduct, that he went to meet his learned counsel, who did not share any information with him. Full stop. It is also not the case of the petitioner that he went to the concerned tribunal but did not get any information about the dates on which his case was posted. So therefore, comma, on the basis of materials available on record, the court is unable to arrive at a conclusion that there was any communication gap between the petitioner and his learned counsel. Stop. Moreover, comma, inquiry regarding the conduct of the learned counsel for the petitioner cannot be gone into in this writ petition. As there are alternative forum available for the petitioner to raise these issues. Next one. Ordinarily, comma, if there's an adequate explanation of the delay in not participating in the proceedings before the learned foreigners tribunal by filing a written statement, comma, court has to examine as to whether the learned tribunal given adequate opportunity to the petitioner to present his written statement of defense and of the court representation as referred to in the foreigners within bracket tribunals bracket close order, 1964. In this case, we find that the learned tribunal was too liberal in granting adjournments. And despite failure of the petitioner and his learned counsel to appear before the tribunal on 2 occasions, the tribunal did not show any haste in passing an opinion immediately. So therefore, comma, this is not a case where the court can arrive at a satisfaction that there was a communication gap between the petitioner and his learned counsel. Stop. Moreover, comma, as mentioned herein before, comma, all the certified copies of the voters list referred above were available with the petitioner, and therefore petitioner took a calculated chance of not filing his written statement of defense within the time and or extended time granted by the learned tribunal. Next, therefore, comma, though citizenship is a coveted right of a person, however, comma, in this case, the petitioner, despite being aware of his constitutional right, has slept over his legal right by not filing his written statement within the time allowed. Next paragraph. Under the provisions of the foreigners within bracket tribunals, bracket close order, 1964. Under para 3 within bracket 8 of the said order, the foreigners tribunal is required to give 10 days time to the proceedee to give reply to the show cause notice, and further 10 days time to produce evidence in support of his or her case. So under paragraph 3 within bracket 14 of this said 1964 order, the foreigners tribunal is required to dispose of the case within a period of 60 days from the receipt of reference from the competent authority. Full stop. Though there is no provision for extension of time beyond 60 days. But under paragraph 3 with capital C, 3 dash capital C of the said 1964 order, procedure is prescribed for setting aside an ex parte order if the proceedee can satisfy the tribunal that he or she had sufficient cause for not appearing before the foreigners tribunal. Stop. However, the said application is required to be filed within 30 days from the date of the order. There is no provision for extension of time or enlarged time to entertain application for setting aside an ex parte order. Next paragraph, therefore, in light of the discussions above, court does not find that the petitioner has been able to show cogent reasons for not being able to file his written statement despite matter being adjourned on 12 occasions between 5/7/2023 and 11/6/2024. Next paragraph. This is judgment of this court on not setting aside the ex parte order.
Yes, Lordship. Yes. One is Lordship, 2016 1 GLT 273 Lordship.
Name of the parties.
The Ayub Ali and another versus Union of India and others. AIUB.
AIUB.
Ayub Ali Muhammad.
In this regard, we may refer
Lordship,
to the case
paragraph
of
16.
Ayub Ali versus the state of Assam and others, 2018,
2016 1 GLT.
this is 2016 within bracket 1, bracket close GLT,
273. Para 16 Lordship.
2016 1 GLT page,
Page 273. decided on 15/12/2015. Para 16.
Ayupali within bracket MD, bracket closed. Paragraph 16 thereof is quoted below. It
Principle
starts from principles of natural justice.
cannot be put into a strategic.
And the last two words are self dash defeating, inverted comma closed. Next paragraph. The court does not find any good reason to not follow the judgment rendered in the case of Ayub Ali within bracket Mohammed, bracket close within bracket Supra, which has a binding precedent, comma, in the absence of any cogent or acceptable explanation from the petitioner for not being able to file his written statement of defense. Despite the proceedings being adjourned on 12 occasions. Next, accordingly, this writ petition fails and the same is dismissed at the motion stage without issuance of notice on the respondents.
Obliged.
Item 7 for motion.
Yes, which page is the opinion?
Open your lordship, page 52. That's relevant.
5-2.
52.
24 opinion, we grant bail.
Yes, sir.
Petitioner. Mr. S. Hawk, learned counsel for the
Yes,
petitioner.
Islam. Yes, Islam.
S. Islam, I'm sorry. S. Islam, learned counsel for the petitioner. Respondents are there. Ms. Bedi on behalf of Ms. P. Barwa. Page 52 is the opinion dated 21/6/2024. Notice extra copies within 2 days. Call for the records. Prayer for bail is opposed by the learned standing counsel for the FT matters. However, considering the projection made in this writ petition, bail of Ms. 5,000, 10 days time to the satisfaction of
SP Border Dhoburian.
SP Border Dhubri. Okay. Please start of office of the CEDAW records. Acknowledged. দুটো আছে মোশন দিতে। ও 7 হলো 8 আছে হ্যাঁ। না এটাতে মোশন দিতে। Yes, Mr. Sikdar, which is
My
the
lord.
opinion page?
Opinion, lordship will find at page 72. September 30, my lord, 24.
32.
My lord,
Page
72.
72. Okay. Thirty-nine 24.
Yes, my lord.
Then you have to wait for some time for bail.
39, my lord, September 12.
Oh, 39 24. I'm sorry. I
24.
misread it. Okay. 39 24. Okay, same. Bail. Page 72 is the opinion. Mr. A.R. Sikdar and counsel for the petitioner. Mr. M. Islam on behalf of AI Ali. Bill 5,000 to the satisfaction of
SPB Golpara.
SP Border Gwalpara. This man will be offended.
My lord.
This superintendent of police will be offended. He will not give you bail. Look at the spelling.
My lord. Superintendent. Oh, my lord. Yes, my lord. There's some mistake, my lord. I'm sorry, my lord. Superintendent. May I correct it, my lord? That's all.
No, you can't do it here. You'll have to do it in the central registry. You'll have to give an amended cost title.
My lord, we'll file a mistake.
Spelling mistake in the nomenclature of superintendent of police, border Gwalpara.
Superintendent.
Within bracket respond number 4. Just on the prayer made by learned counsel for the petitioner is permitted to amend the cost title by providing a specially typed of cost title to the AOJ FT section. Issues of certified copy will be delayed till cost title is amended.
We'll
Yes,
file tomorrow, my lord.
you can do it today. You
My
will
lord,
be
yes,
corrected.
sir, I will
Otherwise,
do it
it will take
tomorrow.
time. We have said that the certified copy issues will be delayed.
My lord, my lord,
Now we have unlimited time to correct it.
my lord. I'll finish it.
Upgraded item 45 for admission.
Mr. Sharma, in this, I could not go through the LCR. Please check it. I did not see it. What is the best document you have to connect you to your
My lord,
projected parents, apart from voter list?
My father, my lord, died prior to 1966, my lord. My elder brother's name, my lord, enrolled, my lord, 1966, my lord. Page 26, my
No,
lord.
no. Apart from voter list, do you have any document?
My lord, my father's name enrolled, my lord, recorded in the Dakila, that is, my lord, page 24, my lord. It is, my lord, 1958's document, my lord. And my name also recorded in the voter list of 1977, my lord. My father's name, Noimuddin Sheikh. These documents is for in the year 1958, my lord. My name recorded, my lord, 1967.
What is the name of your father?
My lord, my father's name is Noimuddin, my lord, Noimuddin Sheikh.
But then this Dakhila doesn't help you.
My lord, and NRC also I have recorded, my lord. So though it is not very well, my lord, but
Page?
my lord, page 24, my lord, 22, my lord. Type copy, my lord, 22. My elder brother's name, my lord, recorded along with my father, my lord. And my elder brother's name recorded in the voter list of 1966, 1970, and 1977, my lord. My name recorded along with my elder brother, my lord. But in that 1977 voter list, my lord, my father's name wrongly recorded as Nawazuddin in place of Noimuddin. This discrepancy, my lord, occurred, my lord. I have stated in my lord, WS also, my lord. This is the discrepancy, my lord. Noimuddin, Solimuddin. Elder to father,
Solihuddin, Alihuddin. Alihuddin, Solihuddin. Alihuddin, Solihuddin, Mohibol, তার লড়াইট প্রেসিডেন্স।
লোরার নাম কি?
লড়ার নাম কি আছে সাইড? লড়ার নাম হল আব্দুল সালাম। সালাম আলিউদ্দিন। Please. In the voter list of 1989 also, my name is recorded. Just a moment. Voter list of 1989, my father's name correctly recorded. Just a moment. My lord. In your written statement, you have said that Bholar Char and Nair Alga is
My lord, yes, my
two
lord.
different places.
No, my lord,
Two
two different places,
same place or two different
Yes, my
names.
lord.
This we are not getting anywhere.
It was known earlier, my lord,
No, but-
clerk has, sorry,
This
Uh,
is something we are not getting.
originally it is my lord, Nairelga, my lord.
How much distance this from Bilasipara?
My lord, about 10 kilometers, my lord.
Then it doesn't match. There will be two different places. Nair Alga and Bhularchar would be two different places. Because from Bhularchar to Bilasipara, distance shown is 33 kilometers. Oh, sorry, I've said it wrongly. Nair Alga to Bilasipara is 33 kilometers.
33. Yes, my lord. Maybe, my lord. Nairelga to Bilasipara, 33 kilometers.
Mr. Sharma, is there only that place?
Okay.
If the two places are same, that he may have some case. We'll grant bail and then consider. You have not been arrested?
No, my lord.
Okay. But Mr.
A. Hussain.
A. Hussain, done counsel for the petitioner. Respondents are there. Mr. M. Islam on behalf of ARD. Opinion dated 31/10/23, page 64. Notice extra copies within 2 days. Records have already come. The prayer for bail is opposed by the learned standing counsel for the FT matters. On the ground that the learned tribunal had appropriately dealt with all the exhibited documents. and held that the petitioner had failed to prove that he's a Indian citizen. And moreover, the petitioner had only produced photocopies of the voters list of documents and failed to exhibit most of the original documents. Next, be that as it may, as the examination of records received requires some, we would require some time. Court is inclined to bail to the petitioner. This 5,000, 10 days time to take bail to satisfaction of
SP border Dhubri Mendo.
SP border Dhubri. Okay. Any other matter which was upgraded?
I don't feel nice.
Item number 2. I will just, my lord, 12 minutes, only for the purpose of distinguishing my case, my lord.
Item
Mr.
number.
Das is ready.
Item
His
number.
argument, my lord, he will argue item number 47 in today's list, the first day's request. Item number 2, it is, my lord, 75 of 2000. Retable number 75. I'll just distinguish, my lord. I'll not, yesterday, my lord, I heard what Mr. Chaudhary argued. I will not repeat that. I may endorse. It all started from the question 75 to this. It will take whole day. Day after tomorrow, I will not be here, my lord. Therefore, what I propose.
Yes.
So what I propose, my lord, I will distinguish my case, and after your lordship does it the matter for CAB, my lord, my junior will submit just a 3-page note, 1, 2, 3, 4, which normally comes handy, my lord. That is a difficult job to again search for that. My lord, my
So if I have to avoid that, I'll have to pass a oral judgment.
that is right, my lord. So that I assured, having assured that what I say today will be followed by just 3-page, my lord, 1, 2, 3, 4. No, not a huge, my lord, paper. My lord, factually my case is slightly distinct. There is a distinction in the sense that the police report has been the basis. And it has been argued that the police report by itself cannot form the basis Lordship is taking item WA 75. So basically, all along it has been argued, and all of us, my lord, argued before the other benches when the matter was heard at length, my lord, that the crux of the argument is mainly that the police report by itself cannot form the basis to derive a subjective satisfaction by the governor and then to pass a discharge order, which again says that I am unsuitable. I don't have to repeat that. It has been argued at length, madam. So, I am before your lordship to say that the learned single judge's judgment He, my lord, relied on statements by all these petitioners. Maybe one, I don't know about others, most of the petitioners and the writ appellants, my lord, that they made statement either under 161 IPC or under 164 erstwhile IPC. Now BNS. Lordship, I beg to take your lordship to paragraph 48 of the single judge judgment, which your lordship will find at page 324.
Yes.
324 running page. Yes. Paragraph 48, Lord. Dismissal police report following investigations are part of records and compilation of the same has been furnished before this court by D.K. Misra, learned senior counsel. During the course of hearing, it is seen that illegalities, irregularities discovered in selection had been scrutinized and investigated upon in respect of each of the writ petitioners. Detailed police investigations enabled to pick out candidates who had lawfully benefited. A perusal of the report leaves no room for doubt as to the thoroughness with which the investigation was carried out. Irregularities attributed against each of the petitioners are minuted, reinforced. Statements made before investigating officer by such petitioners, meaning thereby 161, as available in the records, admitting to their complicity. Having gone through the police report, prima facie view of this court is that the same comments itself acceptance. Question is, could such selection in respect of petitioners be acted upon in the matter of public employment? Also, whether the state respondent could have acted upon the police report to eventually discharge petitioners from service. No law is cited on behalf of the petitioner to support the view that there is legal embargo in acting upon police reports as seen to be done in the present cases. On the contrary, decision in Kishan Jadhav and Chandradhar goes to support a contention that police reports can be acted upon. This court, however, would hold that orders of discharge which are subject matter of challenge in the present case do not suffer from any legal infirmity only on a contention that the impugned orders are based on foundational facts emanating from reports of the Dismissal police. Orders of discharge from service found on police reports are one thing and orders founded on misconduct altogether different. What is relevant in the present case is to ascertain whether orders of discharge were founded on misconduct as understood in service jurisprudence has already been answered in the negative in the positive. So thereby what it says, what this paragraph says, that the learned single judge has stated clearly that in case of every petitioner, in respect of every petitioner, by every petitioner, statements were made before police as available in their records, admitting, the word is admitting to their complicity. Having gone through the report, prima facie view of the court that the same comments itself to acceptance. Now, I am one who neither gave statement under 161 and I was simply roped in blanketly by the learned single judge along with others. That your lordship will find at my lord, page 319 and 320, running page. Paragraph 43 of the learned single judge judgment at page 319. Applying the above principles to the present cases to ascertain circumstances and foundational facts leading to the discharge of the petitioners from service during probation, the original office files containing notes of arrest and suspension of the petitioner, as well as notes of the decision-making process involving consultations with the approval accorded by high governmental officials are present. Now it starts. The office files contained called for by this court covers each of the 52 petitioners to be precise. Then their name, names are given, code numbers are given. Starting from AAP 148, I will not read all the 30 or 40 names. Come to the next page, 320. The names
But
ends around about the seventh line.
But the same paragraph 43,
Yes,
your name is also there, Pallavi Sharma Chaudhary,
I am coming.
A22.
That is the wrongly quoted. Why I am saying, my lord, that will be during the course of investigation, written answer scripts of the APSC combined were also seized from confidential examination branch of APSC as well as from house of Rakesh Pan. The handwriting samples of the arrested accused person as well as that petitioners were obtained and sent to forensic laboratory. It revealed that the answer scripts were not printed in the government press. This is the second limb of the finding of the police report, my lord. Number one, this person, the code numbers were given, they made a statement either 161 or 164. And secondly, that they used answer scripts which were not printed at government press. Now come to paragraph, my lord, 44. Without entering into any legal arguments as to its admissibility, which is for appropriate fora to decide, office files also contains statements made by a section of the petitioners before police admitting to their complicity in the illegal activity to which they were beneficiary. Here again, these are mentioned. Who made statements? The statements of such petitioners found in the office files are that of so and so, so and so, so and so. Even admissibility of evidence made before police, my lord. The statements of such petitioners found in the office files are that of Rituraj Gogoi, so and so, so and so. It starts. And then, importantly, my code is not here, which is code number A-22. That code is not there. That is where what I am pointing, my lord. Earlier, it named all petitioners, including me. But when it comes to making a statement, admissibility of evidence of a statement before police, my lord, there is what we know, my lord, also knows about the golden rule of Miranda, 1937 Privy Council, 39. Nasir Hussain's case. Here, what I want to point out, kindly tally the numbers. Nowhere my code is here. A22 is my code. Am I clear to you, lord? Secondly, come to the answer skip portion.
That is not a code. That is your accused number. You are accused 22.
Yes,
A22.
that is not there. Now coming to the, my lord, answer skips, I have filed an affidavit, my lord. I have second part. My admission, purported admission as per police report, and my complexity about not using the officially printed answer script. There was a, my lord, affidavit which I filed on 24/22. I don't know the, my lord, I'm sorry, the running page I don't have. Has you got that affidavit?
Just a moment. Yes.
My affidavit, lordship, very short affidavit, my lord, filed on 24/2022. There, your lordship, there was an RTI file, and lordship may kindly turn to page 7A, document number 2. This was an RTI filed by one Topon Das to the Government of Assam Directorate of Printing and Stationery Assam, which prints, my lord, the official gazettes. Government press. And page 7A is the reply to the RTI.
Yes.
Page 7. Lordship will find it is dated Guwahati, 7th of October 2021, from the so-and-so Public Information Officer, Directorate of Printing, Guwahati, furnishing of information under RTI. It is in respect to a petition dated so-and-so. With reference to the subject cited above, I would like to inform you that no answer scripts / sheets / khata of combined competitive main examination 2013. This is 2013 examination, my lord. All these bunch of petitions conducted by APSC was printed at the Assam Government Press. Am I clear, Lordship?
Yes.
So to accuse me and implement, and that is also, Lordship may also have a look at page 9. Same information. Roman 2 information. It is also 25th November, few days later, 21. There is no standing order. Notification of Government of Assam to print scripts khata APSC and the Assam Government Press. Directorate print the answer script only after receiving any specific order. So it is not a routine matter or a compulsory requirement that APSC answer scripts have to be printed at the Government Press and nowhere else. And page 7A makes it abundantly clear that so far as the main examination of 2013 were concerned, no answer scripts, sheets, khata of combined competitive main examination was printed at the Government Press. Therefore, on both these
But,
grounds,
Mr. Barbara,
Lordship.
without knowing the question, how will you appreciate the answer? Where is the RTI query?
My lord, when one sits in the examination hall, whatever answer scripts, khata is produced, my lord, I write on that.
No.
Whether that is
No,
from
that's not the query. The query is in this affidavit, the RTI query is not there.
RTI query is there. RTI query is there. In any case, it is the reply under the handle seal, my lord. RTI petition is not there. Petition here.
Because
Petition
here
is
it-
mentioned. Page
because-
7A, petition is
No,
mentioned.
because here it says APSC placed their last order for printing of answer scripts
Yes,
on 27/5/2019.
that's right.
Now we are dealing with what you call this.
RTI,
No. This examination of the year
2013.
2013. So it does not exclude 2013.
I said in 2013.
That's what I'm asking you. You see, since the RTI query is not there,
RTI query is here at page 6.
page 6.
Page 6.
No, page 6 is the reply.
No, page 6 is from me, my lord. Assistant Director.
Joyanta
Yes,
Chaudhary, from
no problem.
Joyanta Chaudhary.
Yes, my lord, it is typed out. Here it mentions about a petition dated nil, petition number nil dated 14/9/21, which clearly means. And the
No,
next.
we are not questioning you.
Right.
We are not questioning you on that. What we are asking is that in the reply which you received
Yes,
at page 9,
page 7A, lordship may have a look.
7,
Page 7A, that is the most important.
7A.
Yes, that is the specific reply. 7, page
I would
9
like
is
to
a
inquire
general.
whether no answer scripts of combined so-and-so conducted by APS printed. Okay.
It refers that furnishing, this information is furnished
Okay,
as per
2000
petition number dated 14/9/21. It, the fact remains that, now I think I am clear, lordship.
Okay, yes.
There was a petition. There was a petition by someone dated 14/9/September, and on 7th October, you as a public relation under the RTI Act, you state that no answer script khata was ever printed for 2013 batch of examination. Am I clear now?
Yes.
So I leave this here. This, I leave this point here. I have a very short argument thereafter, my lord. The question is, I am not amongst all the candidates, yet the learned single judge without application of mine roped in my name. Roped in and bracketed my name. Though I was not the person who either made a statement under 161 or 164. And to talk about the answer script, well, I wrote answers on the script that was provided to me. I don't know whether the source was from government press or elsewhere. That is not an offense for me. Everybody's involvement has to be seen separately. If illegalities are, my lord, all pervading and vitiate the whole selection, then the question of natural justice will not come. You cancel the entire election and direct to hold the examination de novo. There are plethoras of cases in this country, my lord, including railway board's examination. Then no, the entire examination goes. This is not the case here. Out of several hundreds selected persons, about a few dozens were picked up. So this is a learned single judge, the police report being the base. Even this is sweeping and roping in all of us, including me, without proof of any fraud or criminality on my part. Then
Can
my
you come
lord-
to page 219
Lord-
of your brief?
Lordship. Yes,
Paragraph 11, about 5 lines
Lordship.
after that.
Lordship.
Interestingly, the
Yes.
police authorities have not even this is your reply. Interestingly, the police authorities have not even interrogated the petitioner except for asking her name and address, etc. As such, the petitioner has reasons to believe that the authorities, in order to victimize the petitioner, may manufacture something. So the police interrogation was there, but something else.
Supports me. This paragraph supports me. Where do you live? Where are you from? This was what the police asked. The police DSP asked me, what is your good name, madam? Where do you live ordinarily? Guwahati or
They
Dibrugarh?
ask your good name and write a bad name.
So anyway, my lord, continuing, my lord. Mere detention with a PS case and then filing a charge sheet in an appropriate court of trial by itself cannot legally entail a termination simpliciter. More so, by saying that you are unsuitable. I will not repeatedly come to the impugned order of discharge. Lordship has seen the order on many occasions. And I will not also refer to Rule 20. See, what is discharge? Conditions precedents for such discharge from public service under Rule 20C not fulfilled. It was already shown, my lord, that book, Rule 20C. I will not repeat. I'll try to minimize the length of my argument, my lord. Mr. Das is also waiting. On deemed confirmation, the government's plea that there could be continued probation beyond the stipulated because of the pendency of prolonged investigation is not sustainable. It is not correct, my lord. So far as I am concerned, from 8/11/2017 to 12/10/2018, I was detained. Then enlarged on bail by competent authority on 12/10/2018.
Your
20
arrest was from which period to which period?
I was detained, my lord, 8/11/2017. That's correct.
Till
12/10/18 enlarged on competent, enlarged on bail by competent court. 12/10/18.
18. Okay.
2011/17, the suspension order was issued while in detention, even as a provision. And by the way, I have, my lord, stated that I earned 1 or 2 increments as a professional. 1 or 2 increments as a, well, under service and disciplines, the moment one is suspended and put behind the bar for 48 hours, automatically suspended. No question about that. I ought to have been kept under suspension as long, even thereafter, sometimes the suspension is removed. That's what, that is not the case. On the basis of police report, trial is going on. Trial is going on. I don't know when this will be concluded, to 2027 or 2028. Till one is not proved, the law is very clear, the service jurisprudence is very clear. What if I am acquitted by the court? Who will compensate for all these things, and who will compensate for the stigma that I have suffered? If I am convicted, well, that's the end of the matter. I go there, I go on a criminal appeal. So far as this service is concerned, matter ends there. Am I clear, my lord, with respect? So no plausible justification for issuing the order of discharge. Suspension could have been continued. That's a different thing altogether. You are not doing that. After all, even probationers have some established legal service protections. The German consideration should not be mere completion of police investigation. It must not merely wait for such completion of investigation. It must wait till the end of the trial. No accused is guilty unless proved. And to talk about, my lord, fraud is there are some big words used by the other side, like Senior Counsel also. Scam. Fraud. Scam is a word which is better sounded in television, not in the IPC. You will not find in the penal law, the court, any offense called is scam. Fraud is a perception which is not based on unilateral conclusion. Criminally, it has to be tried. Service law-wise, you must give my minimal right of defense even for arriving at the preponderance of probability. Not strict as proof like criminal trial. Fraud has to be established and proved both ways. In criminal trial as well as in service parlance. You cannot put a proven seal of fraud unilaterally in either parlance. At least it is not what the relevant Indian laws, criminal or service laws allow, nor does the Constitution. Any revelation in criminal investigation is not the gospel. That Iowa's police report furnished before the learned single judge could not be called and is not gospel. Paying money to secure appointment has to be proved. Easier said than done. Proved. You cannot summarize all these perceptions and presumptions on a police report like this one. And then you pass an unilateral non-speaking order in the name of governor purportedly under Rule 20. See? I dare to submit, my lord, with respect that the perusal and the solitary perusal and taking the police report as the solitary basis with incriminating observations by police, the so-called materials against a few could not have formed any material basis for a subjective satisfaction or for adjudicational satisfaction for the learned single judge and subjective satisfaction for the governor under Article 311. The provisos to that. I take your lordship to 311 again, my lord. Constitution. It has to be a rational decision making based on a rational subjective satisfaction. 311(2) Constitution. No such person, no person is a member of civil servant, so and so, state be dismissed or removed by the authority. We are on 2. No person, that means civil servant, as aforesaid shall be dismissed or removed or reduced in rank except after inquiry in which he has been informed of the charges against him, given a reasonable opportunity of being heard in respect of those charges. Now there are provisos. Lordship will kindly see 2. Where is the proposal under the proviso and where it is reflected in the cryptic impugned order, that it is reflected or it is reflected in the file notes. There are the provisos. A, B, C. Provided where it is proposed, inquiry impose upon him any such penalties. Penalty may be imposed on the basis of evidence adduced during such inquiry, and it shall not be necessary to give person any opportunity of making representation. But there has to be where it is proposed that inquiry. Provided further that this is important, shall not apply. Where a person is dismissed, removed, reduced on the ground of conduct which has led to his conviction. That still has not come. Where authority empowered dismiss, remove a person, reduce him, being satisfied that for some reason to be recorded by the authority in writing, it is reasonably practicable to hold such inquiry, not in this case. Where the president and the governor, as the case may be, satisfied that in the interest of security of the state, it is not expedient. This is not the case. Therefore, which is the power? And this is a case which is neither termination simpliciter nor a panel. It said unsuitable. When a person becomes unsuitable for a job, when he becomes a lunatic, maybe, declared by a civil court as what it is called in Assamese, my lord, Deolia, liquidator. Oh yes, there is, yes, you are not fit. You are unsuitable. You are unsuitable. Nowadays, even physical disability is not unsuitability. I will not go into all those decisions. One may be differently able and holding a high post. Proviso A, I am not convicted. Proviso B and C, not applicable. 3, how do you unilaterally derive the conclusion that it is not reasonable or practicable to hold an inquiry? Why? Because the police report is there. And another word is tainted. I will not go. It is for the field of political mudsliding, not for legal arguments before a court of law. Accused is an accused. What do you mean by tainted? Probationers like me completing every mandated training on-job experience under a state administration cannot be treated like private contractual employees solely on the mercy of the private and unregulated employer, hire and fire. There is bound to be a differential treatment. More so when someone completes his training blemishlessly as a professional, and after that, given increments, you delayed my regularization for 6 months, 9 months, 1 year. Am I to be held for it? Does it doing that? But can you take away or can you convert it to a relationship between a private employer and a private employee? No. If at all I was in probation, it was in respect of a government service. If I completed a training, it was a government training. If I was given an increment, it was government granted increment under the law. You cannot exploit, deprive, deny even a probationer as per your suit will. When a particular set of service rule is silent about detailed procedure or methodology, suppose the service rule is silent, the existing juristic principle pertaining to my vested rights, my right to have natural justice, right of deemed confirmation, maybe notional, will come into play. Failure or inordinate delay on part of the appointing authority to confirm the service even after a mile of completion of training, award of increment, cannot take away my right of being fairly treated as a public servant. You cannot simply cause unnecessary delay and use it as a pretext to deny minimum service guarantees to me. You cannot have the cake and eat it too. Therefore, my lord, to sum up, the stand of the government is self-contradictory, self-defeating. If you say fraud, you have committed fraud in getting selected, obtaining job. If this is the reason for discharge, you just cannot say that you are unsuitable, therefore you are discharged.
Please,
Arrest.
please repeat that again.
What is it?
Please repeat that again.
My lord, the stand of the government is self-contradictory and self-defeating. If you allege some offense of fraud, forgery, in getting selected and in obtaining a job, if that be the reason for your discharge order, you just cannot again say that unsuitability is the reason. Unsuitability is non-criminal, may not be non-criminal adjective. It is not a criminal adjective. And in that case, you will have to give reasons. There will have to be records. There will have to be minutes and notes. Well, Mr. Barbara is unsuitable for reason 1, this, and this reason.
The question is, can we say it?
Oh, my client.
I'm just, since I can smile with you like I am doing it, no offense meant.
So, these are the questions, and only thing, Rule 20, there are 5 situations laid down wherein a professional can be. Rule 20, I will not read. Condition A, B is there. Then came to, I think, yesterday, so we also pointed out to Rule 20C. I will not repeat to save time. Go to C only C. 20C. It is only C, within bracket C, 220C, which demands a satisfaction that I am unfit or ineligible. And three things are related here. There has to be a satisfaction based on materials placed before the governor when the governor says you are unsuitable. He cannot find me unsuitable without any material basis and in the air. There must be some certain materials placed before him on the basis of which only the governor can take the satisfaction and write it down, terming me as unsuitable. Opportunity must be given. Because it brings a stigma to me, stigma on me. And so far as D and E, these are not relevant. I am not wasting time. At least I was entitled to a notice. Condition kita kun kita? Only 4 decisions I have in paragraph. Your lordship may note. I am concluding. Yes. This is rights of probationer, my lord. I don't know whether by now Mr. Chaudhary has referred to, my lord. If he has referred, it's fine. 2013, volume 3, SCC 607.
2013?
2013, volume 3, SCC 607, paragraph 30, paragraph 36 and 37. State Bank of India versus Moody. Just 2 small paragraphs. 36 I am reading. Photo design.
Yes.
I am still fond of reading books only.
We had to adopt.
Full timer.
No. We had to adopt.
Adopting. So there
Because if I don't adopt,
no,
then you will have
definitely
to, no, if I don't adopt, then you will have to produce printed copies and give it to us.
That's
So we are saving the bar
I
a lot
must
of
adopt.
effort.
I must adopt. Maybe I need not be a good typewriter, having quality of a typewriting, but many other things I have to adopt. Mine. And gradually trying to adopt more. 36. Paragraph 36. There is a marked distinction between concept of satisfactory completion of probation and successful passing of training test held during or at the end of period of probation, during the period of probation or at the end of probation, my lord. Lordship, kindly highlight it. Paragraph 36. Which are sine qua non for confirmation of a probationer and the bank's right to punish probationer for defied misconduct, misbehavior, misdemeanor. In a given case, competent authority may, while deciding the issue of suitability of the probationer to be confirmed, ignore, or acts of misconduct, terminate his service without casting any aspiration or stigma, which may adversely affect his future prospects. But if the misconduct, misdemeanor constitutes the basis for final decision taken by the competent authority to dispense with the service of the probationer, albeit by a non-stigmatic order, court can lift the veil and declare that in the garb of termination simpliciter, the employer has punished the employee for an act of misconduct. Even the word is innocuous looking word. Lordship may unveil the scenario, unveil it and go into the scenario behind. Then next paragraph, my lord, 37. Use of unfair means in the evaluation test, confirmation test, held by bank certainly constitutes misconduct. Bank itself treated such act to be misconduct. Paragraph 10 advertisement. It's not in dispute that service of private respondents were not terminated on the ground that they were deficiency or shortcoming in their work or performance during probation, or that they failed to satisfactorily complete the training, or had failed to secure qualifying marks in the test. As a matter of fact, the note prepared by Deputy General Manager, which was approved by General Manager, makes crystal clear that decision to dispense with the services of the private respondent was taken solely on the ground that they were guilty of using unfair means in the test held on so-and-so date. To put it differently, foundation of the action taken by the General Manager was the accusation that while appearing in the objective test, the private respondents had resorted to copying. IBPF relied upon analysis made by the computer and sent a report to bank that 18 candidates were suspected to have used unfair means. Authority concerned then sent for that chart sitting arrangement, treated it was more methodically, treating same as a piece of evidence for coming to the conclusion that private respondent had indeed used unfair means in the examination. This exercise was not preceded by any inquiry involving the private respondents, and no opportunity was given to them to defend themselves against the charge of use of unfair means. In other words, they were condemned unheard, which in our considered view was legally impermissible. Legally impermissible. And here I have also preceding paragraph, I pointed out a particular word, while on probation or on completion of probation. Paragraph 36. One more case. 2010. Yes. 2010, volume 8, SCC, page 220. Then paragraph 42 and 43. Forty-one, it says, therefore, with the said statement admissible as dying declaration, there was a dying declaration, forget it. Events surrounding 42. Events surrounding confession made by A1 while in hospital, more significantly, police custody are too ambiguous to support conviction. Then 43, section 164 provides guidelines to be followed for taking a statement of the accused as a confession. One essential condition that it must be voluntary and not under threat or coercion. And Lordship knows about it, my lord. We one is one person twice. That's all right. What you are confessing may go against you. Go. Take a seat there for 15 minutes, then come after and again confess. I need not explain it to your lordship. Then, my lord, paragraph 45. As has been held by this court in state of UP, this is a case of old case 64. Statement that doesn't prescribe to the procedure laid down 164 is not admissible as a confessional. In that case, the statement has neither been recorded. I'm sorry. I'm sorry. This is slightly pagination is slightly sorry. Extremely sorry. Yes. My lord, Lordship may take up this same Union of India Mohabir, page 242, page 42. Para 42, my. I'm sorry, my lord. I was reading the other books, para 42. I'm sorry. I wasted 2 minutes.
Yes, okay.
Para 42, my lord. Para 42. From the facts as disclosed and the submissions made on behalf of respective parties, there is little doubt in our mind that order dated so and so by which the respondent was charged, discharged from service was punitive in character and had been motivated by considerations which are not reflected in the said order. Keep aside what Learned Singh just said. Come to what the governor said. Not recorded the considerations. Simply said, you are unsuitable. Then 42. Petitioners have not been able to satisfactorily explain why rules, norms, allotment of languages were departed from the year so and so the respondent was denied his right. Last portion. Reason for us to deal with this aspect matter is to see whether the case of the respondent is covered by views repeatedly expressed by Purushottam Lal's case onward to the effect that if inquiries on allegations made against an employee form the foundation of the order of discharge without giving employee concerned an opportunity to defend himself, such an order of discharge would be bad and liable to be quashed. Emphasis. Paragraph 44. In addition to above, then Minister of External Affairs appears to have taken an active interest in complaint made by so-and-so, although nothing was found against the respondent on the basis of the inquiries conducted. The same was taken into consideration, which is reflected from the observation made by so-and-so Joint Secretary, that he had no doubt that the respondent would blacken the country's name. There is absolutely no material on record to support such an observation made by a responsible officer in the ministry, which clearly discloses the prejudice of the authorities concerned against the respondent. It related to security and external affairs. Even there they said. Paragraph 5. Since High Court has gone into the matter in depth after perusing relevant records and the learned additional Solicitor General has not been able to persuade us to take different view, we see no reason to interfere with the judgment and order of High Court impugned in this SLP. Not only is it clear from the materials on record, but even in their pleadings, the petitioners have themselves admitted that order dated so-and-so 2002 has been issued on account of the respondent's misconduct, and that misconduct was the very basis of the said order. That being so, having regard to the consistent view taken by this court that if an order of discharge of a probationer, hear the word probationer like me, is passed as a punitive measure without giving him an opportunity of defending himself, same would be invalid and liable to be quashed, and the same finding would also apply to respondents. The last one, 74-2. This is some such thing, I think it is known to your lordships. Even then, I will not read it. 74-2 SCC 831.
Please give the citation again.
The 7 judges bench.
Please give the
7 judges.
citation again.
1974-2 SCC 831. Some such thing, man. 7 judges. Here, I am abstract 63, 64, coming straight away to 80. Paragraph 80. The order of termination of services of so-and-so Agaral is by a punishment in the fact circumstance. High Court is not denied itself under Agarwala the protection under 131, but also denied itself dignified control of the subordinate judiciary. From the order is not decisive as to whether order by way of punishment. Even an innocuously worded order terminating the service may, in the facts and circumstances of the case, establish that an inquiry into the allegations of serious and grave character misconduct involving stigma has been made infraction of the protection of Article 311. 311 means the proviso ABC, my lord, which I referred to already. In such a case, the simplicity of the form of the order will not give any sanctity. You are passing a very innocuous, simple order that will not give your order a sanctity. This is exactly what has happened in this session. The order of termination illegal and must be set. With this, my lord, I conclude. I am my obliged for giving valuable time, and I am sorry, I kept Mr. Das also awaiting. He was ready with his argument. My junior will just give a 3-page note.
That is your personal affair. You can compensate
No,
him
no, man.
adequately.
I told him, I requested him. He was ready.
You
actually.
can compensate him
Took a bit more
adequately.
time. I said, so with this, I conclude. My lord, maybe by Friday or next Monday, only 3-page note, so as to make it handy for your lords. Obliged, lords. Sorry, guys.
In fact, well, in a very lighter way, before I start, because it should be also lighter in the court. Before I start the matter, because I was a second down player in this case. First down, Mr. Chaudhary, second. My learned senior friend, Mr. Barber said, no, you please give me a chance, at least 15-20 minutes, I will finish it of the matter. But he took time. The lawyers, your lordship, we normally give time, but we can't end. That's the whole problem with us. Now, why not in very lighter vein also, I was before the learned division bench. Why is very important. Before the learned division bench, who is the predecessor, the Honorable Chief Justice, Sandeep Mehta was taking up this matter. So I was there a 4th down player. So when I started, because I have seen, my lord, other all my friends who is on this side arguing the matter only on the point of the principle of natural justice, they strike that. What I feel that principle of natural justice should have been followed 2011. But this same argument was advanced. But when I started, I told the court that overall I support, yes, I am with them in so far as principle of natural justice concerned. But my argument, why these orders, for my lord, the order was passed by the Honorable Chief Justice. Because your lordship, as I have noted down, your lordship has also asked me. I made a note for the chapter wise, what I am going to submit before this court. Now, my lord, your lordship remembers that some additional facts was brought before the learned division bench. That was a query that has been put, whether at this stage, whether we can intra-court appeal, whether we can decide this matter or not. Now, I'll come to that, my lord. While deliberating, my lord,
You were in which item? Which is your lead case?
I'll tell your lordship, my lead case, item number 89. Item number 89.
Does he? Item 18.
Lordship will take item number 89. Item number 89.
Yes.
My lord, there are some other matters, but your lordship will kindly take this first, my lord. Item number 89. He belongs to taxation department.
Yes.
He belongs to taxation department. So, my lord, your lordship, when we moved the matter, because I was not before the learned single judge division bench, I was engaged and I appeared for the respective parties. So at that relevant time, my lord, the pagination, your lordship will kindly see, there was a system earlier, it was running pages we have to mark, like 200, 201 like that. But there was some error, some mistake with us. At that point of time, the running pages were not there. Then office decided the Honorable Justice Chief Justice decided that we have to put running pages. According running pages were made. So now, my lord, our case is as per the court's, my lord, paper. There was some mistake. We took leave of the court that mistake should be corrected. Accordingly, we have corrected. So it is on the basis of running pages. Now, my lord, what was there in the earlier round of litigation, today I felt before this court, in this case, most important is the pleading. I think that is most essential, the pleading of the parties. Now, before that, my lord, first query that was put before this honorable court. Yes. My lord, the first query that was put before this court, I have to clear the mind of the court, because I remember it was a question that was put to my learned friend, Mr. Kohli, and he almost said both has to give a reply. Because there was a doubt on the mind of the court, whether additional fact can be considered by the appellate court under Article 226. I think this what your lordship wanted to know. My lord, my answer will be yes. Your lordship can. My lord, can I place the judgment, my lord? I'll start, my lord. There are 4 judgments. I'll start the judgment of our division bench. My lord, 2024 SCC Online Guwahati 2048.
Please give it again.
2024 SCC Online Guwahati 2048. That's what is before your lordship. Already I have handed over.
Okay.
That's already I have handed over.
Yes.
My lord, this is a matter where power of the appellate court, whether they can decide an issue not decided by the learned single judge. Now, if your lordship looks into 128, para 128.
No, this particular judgment was passed under very unique circumstances.
Yes, I know. This
Here-
that I
Here,
know.
part of the land was acquired, some part of was not acquired, and then there was a issue regarding compensation.
Yes, correct. But I'll show more judgment, my lord. Just start off let me place the division bench. What this coordinate
Because
bench.
here, I just cursorily looked earlier.
Yes.
It appears that if no orders are passed for compensation, then there would be injustice because land has already been taken over. So
Yes.
perhaps that and
Yes.
the issue of Zirat.
No, issue. Suppose, my lord, an issue which has not been decided by a learned single judge. Now, this has been brought notice to the learned division bench. Then what happens, my lord? Lordship has put a question. Even, my lord, let me go in a systematic manner, my lord. Then even this point, my lord, when I started before a division bench, this point was asked. Your lordship has put a question. This point was asked by the division bench, the division bench. Then earlier, I said that we have taken that point. Before the learned single judge, the court said, you have taken that point. Where you have taken that point? Then I have showed the pleadings. This is the point which you have taken. It's not that case that we have not pleaded before the learned single judge.
Not a new point.
This is not a new point at all. But even when your lordship has put a query, let me give an answer to it. Why not kindly see 128, paragraph 128. Lordship got it? Be that as it may, Lordship, my Lord Honorable Justice Nandi has found. Yes. Why not 128. Be that as it may, the second aspect which arises for consideration before us is as to whether we, in exercise of the intra-court appellate jurisdiction initiated by the state of Mizoram and not by those writ petition, can exercise the power which the learned single judge ought to have exercised. To decide this aspect, we find it very relevant to take note that on perusal of Article 226(1) of the Constitution, which empowers every High Court throughout the territories in relation to which it exercise jurisdiction to issue to any person or territory, including in appropriate cases any government within those territories, direction, orders or writ, including the writ in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, or any of them for enforcement of any of the right conferred by Part 3 of for any other purposes. 121. 129. Clause 14 of Article 366 of Constitution defines the term High Court to mean any court which is deemed for the purpose of any constitution in India to be High Court for any state and includes A, any court in the territory of India constituted or reconstituted under the Constitution of India as a High Court, and B, any other court in a territory of India which may declared by the Parliament by the law to be a High Court for all or any other for purpose of the Constitution of India. 130. It is very pertinent to observe power conferred upon the High Court under Article 226 of the Constitution become capable of being exercised in accordance with any general right of appeal from the decision of High Court, and it is nothing in Article 226 of the Constitution which requires that the powers thereunder must be exercised once and for all. In theory, an appeal is a continuation of hearing of the suit or other original proceeding, and ordinarily the appellate court has all the powers which the court of the first instance can exercise. Therefore, when a division bench entertains an appeal from a decision of a single judge in exercise of the power under Article 226 of the Constitution, division bench in deciding such appeal exercise the same power under that article, whether the division bench affirms, reverses or modifies the decision of the single judge. The nature and content of the power conferred by Article 226 of the Constitution cannot be said to have been interfered with by a mere provision for an appeal without anything more to a division bench from a decision of a single judge in exercise of the powers under Article 226 of the Constitution. The provision for an appeal, as would appear from Rule 2 of Chapter 5A of Guwahati High Court Rules, merely therefore regulates the exercise of power by our High Court. 131, my lord. In this regard, we find it pertinent to observe that in the present intra-court appeals, which are dealing, the power can be traced to clause 14 of the letters patent constituting the High Court of Judicature at Bengal dated 14/5/1862, which was made applicable to our High Court by virtue of the Assam High Court Order 1948 dated 1/3/1948. Therefore, while adjudicating this intra-court appeals, we are sitting as a court of correction and therefore can correct our own orders in exercise of the same jurisdiction as was vested upon the learned single judge. In this regard, we find it relevant to refer to a judgment of the Supreme Court in the case of so and so, and more particular paragraph 2, which is reproduced as under. This is reproduced. Ramkumar, learned counsel for the appellant, inter alia contends, letters patent bench of the High Court could not have upset a finding of fact recorded by a learned single judge on fresh reconciliation of the two documents, arriving at different result than those arrived at earlier by the two courts aforementioned. Though the arguments sound attractive, it does not bear scrutiny. Against the order of the trial court, first appeal lay before the High Court, both on facts as well as law. It is the internal working of the High Court which splits into two different benches, and yet the court remains one. A letters patent appeal, as permitted under the letter patent, is normally an intra-court appeal, whereas the letters patent bench
sitting as a court of correction, corrects his own orders in exercise of the same jurisdiction as was vested in the single bench. Such is not an appeal against an order of a subordinate court. In such appellate jurisdiction, the High Court exercised the power of a court of error. So understood the appellate power under the latent pattern is quite distinct in contrast to what is ordinarily understood in procedural language. That apart, the construction of the aforementioned two documents involved in the very nature of their import, a mixed question of law and facts while within the powers of the letter patent bench to decide. The bench was not powerless in that regard. Now kindly see 132. We further find it is also relevant to take note of another judgment of the Supreme Court in case of Roma Shankar versus Madhya Pradesh so and so, wherein also the Supreme Court categorically observed single bench as well as division bench exercise same jurisdiction under Article 226 of the Constitution. Under such circumstances, division bench in an intra-court appeal cannot remit the matter to the single judge for molding the relief. The duty of the intra-court appellate forum is primarily to consider correctness of the view taken by the single judge. Para 3 of the said judgment being relevant is reproduced here under. Now, see 133, my lord. The above provision of law clearly shows that the jurisdiction so exercised by the learned single judge as well as jurisdiction so exercised by us in this intra-court appeals are one and the same jurisdiction. That is exercising the power under Article 226 of the Constitution. It is further seen that while exercising the power as an intra-court appellate forum, division bench sits as a court of correction and corrects his own order in exercise of the same jurisdiction as was vested in the single judge. Further to that, that lease which was before the single judge with an appeal being preferred is continued before the division bench. Taking in account of the above, we are of the opinion that we, while exercising jurisdiction, our power in this intra-court appeals can grant the relief which, my lord will kindly see, which the learned single judge ought to have granted in spite of arriving at a categorical finding. Awards have attained finality. Writ petition were entitled to amount. This therefore answer the fourth point for determination. My lord.
But you see, I may just refer to you, if you can just note it down.
Yes.
There is a judgment of the Supreme Court. SCC citation would be 2016 3 SCC 340. 2016 3 SCC 340. In this case, which has the ratio which has been followed in very recent judgment of Supreme Court. I have the INSC citation 2025 INSC 149. This is ordered by Justice Sandeep Mehta. Here, out of two ratios laid down, one is that in intra-court appeal, the court must restrain itself and interference into judgment passed by the single judge only if this judgment of the single judge is perverse or suffers from any error apparent in law.
Yes.
This ratio is taken from the earlier judgment of Narendra Company. So therefore, to take up any other other point.
I'll place one judgment, again one judgment of the Supreme Court. 2014 13 SCC, isn't it? That is 692. Kindly see this paragraph 5.
Just
2000. I have given the copy, my lord.
Yes, yes. Just a moment.
Yes.
I'm looking at something else.
Yes, yes.
Just a moment.
Paragraph 5 says, once the land ceiling having that I could see the conclusion that the industry was not functioning plus to 95, there is no justification entering different finding without any further material. We are bringing further material.
Because
Which judgment it was?
this, Mr. Das, the two judgments I am showing you
Yeah.
for a certain reason, because you see what has happened. This earlier judgment was, I forgot what was the citation,
2016.
16, yes.
SCC
Yes.
350.
Now this 2016 judgment
Yes.
is by a two-judge bench.
Yes.
Now this page, para 132 of the judgment of the division bench of this court you have referred to,
Yes.
the state of Mizoram.
Yes.
Here the reference is made to the judgment of Roma Sonokar.
Yes.
Roma Sonokar again is a two-judge bench.
Yes. The same coordinate.
Same coordinate bench, but taking a different ratio.
Yes.
Then I would refer paragraph I may forget. It's in the case of Pranay Sethi. Five-judge bench, it says para 28 or 29, I forgot. There it says the reference to judicial discipline which has to be followed by
Yes.
one of the bench, coordinate bench. So that is what is stated. It is in this context I am putting you this question.
I just quickly, because now it's available, immediately my juniors have referred to 2016, 5 SCC, which
Yes,
if you-
yes.
2016, 5, if your lordship looks into paragraph 5 of 2016, the 2016 3 SCC 340.
Yes.
Please look into paragraph 5. See paragraph 5.
Yes.
Lordship got it? Paragraph 5.
Yes.
Can I read this paragraph?
Yes, yes, please.
No, your lordship is looking into 2016.
No, your cited case
No,
2014-13.
No, please first look
Okay.
into. I just want to clarify your lordship judgment.
Okay.
Your lordship has cited that 2016.
Yes.
That is 3 SC 340. Immediately I have looked into it, my lord.
Yes, yes.
See paragraph 5. See paragraph 5 of that judgment.
Please give that again, 2000.
2016 3 SCC 340, which your lordship has.
Yes, yes. 2016.
2016 3 SCC 340.
Yes.
Lordship got it?
I'm just getting it. It's
Yes, I'm
closing
sorry,
down.
I could not hand.
No, it's
over
okay, no,
it
it's
to
okay.
Justice Nandi, because I was not carrying the judgment.
No, it's okay.
Yeah.
In fact, it's for some reason it is closing down. That's why.
Yes.
At some point, Lordship, I will just add a sentence on one of the judgments.
Yes.
My lord, see paragraph 5.
Yes.
Because immediately I am giving a response to it, my
No,
lord.
it's okay.
I will go through it again
Yes.
and I'll just give a reply to it. I'll go through it. See paragraph 5.
Yes.
Once the learned single judge have seen the records, had come to the conclusion that the industry was not functioning after January 1995, there is no justification in entering a different finding without any further material before the learned division bench.
Any further material has been brought by the state.
Now, further material, any further material has been brought by the state. I'll show it, my lord. What is the material that has been brought by the state?
We did not bring.
We did not bring that material. The state has brought the material. I'll show the judgment. Sir, my lord, your lordship, earlier, the petitioner, the counsel, Mr. Chaudhary has also operative portion of the judgment was read. And your lordship, I'll place one paragraph of judgment which is very, very important. Very, very important. Your lordship, remember what he said on the last day of the argument, last day, when everything was concluded, on a seal cover, they placed the records, the material which was there before the court, meaning thereby all the investigation that has been carried out, all the statement. I hope that it was placed before the learned single judge. I hope that they have placed before the learned state. In fact, all the documents were before the state. But before the division bench, when we were the accused, under 207, we received the copy before the division bench, before the criminal trial, and we found certain documents which were there under their custody, which was placed before, that was not brought by the investigating agency. That is why the order was, the court was prima facie satisfied, division bench, when the matter was taken up by the court. Court said, Mr. Das, you demonstrate how you are saying, what our case will be, that police investigation is a tainted police investigation, which has been carried out. I will demonstrate, my lord. That is why the court has given us to demonstrate. Today, what was the necessity of the state to form an SIT? Why? With great respect, I will submit, my lord. When I was arguing the matter, I was demonstrating before the court. Say, look here, please. This is what the investigation, there is a tainted investigation. If it is a tainted investigation, where is a question of segregation? And today, when they have formed an SIT, my lord, when I concluded, the court said, yes, you have to give a reply. What do you want to say on this? On the next day, already an SIT was formed. They have left a lot of candidates, which they have shielded. We said, we have documents are there. That's why I'm saying the pleading is most important. Today what? My lord, principle of natural justice is one of the ground. Now today, if I can show that police investigation is a tainted investigation, or I'll show it. The officer who was investigating this matter, he was removed. He was removed. Why he was removed? I just asking a question to myself and asking why he was removed. Why he was removed? This is what the further material after the SIT was formed. All this has taken place. I'll place it. I don't know what is there in the seal cover. Your lordship has said we'll look into it, but you first satisfy. I will say there is also a reason, because I have taken all the instruction of the trial court. What has happened in the trial court? How an SIT was formed? What they have done it? Today, what my argument will be fully that this police report itself is tainted. Investigation itself is tainted. There was no occasion of segregation, tainted and non-tainted. My lord, in the Kalon, those judgments are in place. I'll respectfully, I'll say paragraph 41, what the Supreme Court has said. That your lordship has gone through it. It's not that everyone, you all have to see it. There are some innocent people. Your segregation has to be looked into it. Who has done, who has not done. Then you segregate. And if you find that no, entire selection, should go. It should go. Partially fair, fully, it can't happen. So, where is that concept of a partially fair investigation? Partially fair investigation. That is why, my lord, my argument will be a bit different. If I can satisfy to your lordship that why this order, I am asking now also why the division has passed this order. I'll read that order. But let me complete first with this, my lord, judgment of this 2014-13 SCC, page 692. Kindly see para 5. Lordship got it, my lord. May I read para 5?
The state agreed by the judgment of the learned single judge preferred writ appeal number 906 and 907 of 2012 before the division bench of Madras High Court. While dealing with various directions given by learned single judge, the state represented by learned advocate general pointed out during the pendency of writ appeal suspension order dated 14/12/2012 were issued under section 19(2) of the Granite Conservation and Development Rule 1999, as well as so-called notice dated NIL 12 to 2012, which were issued to a writ petitioner. 6. Further, it was pointed out, departmental proceeding as well criminal proceeding initiated against the petitioner could not be hampered by granting permission to them to carry on querying operation in the 56 peri. The prayer made by Advocate General was opposed by counsel appearing for the writ petitioner, stating that action taken by the government subsequent to passing of the order of the learned single judge could not be the basis for testing the correctness or otherwise of the direction given by the learned single judge. In support of that contention, reliance was placed on the judgment of this court in Mohinder Singh Gill versus so-and-so. Division bench of the Madras High Court formulated two questions which read as follows. 1. Whether the appellant can take reliance on a subsequent events. What you got it? That is passing of the suspension order dated so-and-so and the issuance of the so-called notice dated so-and-so to the respondent writ petitioner for. Now, see kindly 8. See, Harish Salve, learned senior counsel appearing for the petitioner, submitted that he is more concerned with the first question, and the argument were advanced by him as well as C. Sundaram, learned senior counsel appearing for the state. On that point, in our view, division bench of the High Court is right in examining the subsequent event as well in the case where larger public interest is involved. The court in All India so-and-so stating where a larger public interest is involved, the court can always look into subsequent events. Relevant para of the judgment is extracted. We are of the view, 45 was extracted. We are of the view the decision maker can always rely upon subsequent material to support the decision already taken when larger public interest is involved. This court in so-and-so found no irregularity in placing reliance on a subsequent report to sustain the cancellation of the examination conducted where there were serious allegation of mass copying. The principle laid down in so-and-so is not applicable where larger public interest is involved, and in all situation, additional ground can be looked into to examine the validity of an order. The finding record by High Court, the report of CBI cannot be looked into. The examine the validity order dated cannot be sustained. I think, my lord, this is an answer. This is an answer which has been given by the Apex Court. Subsequent event can be looked into it where larger public interest is involved. So this is the second, my lord. My lord, I will just.
We'll have to continue tomorrow because we'll have to rise for the single bench.
Okay. Yes. Two judgments. I will just finish it off, or tomorrow I will.
No, if side judgment, we'll take it out.
Yes, my lord, this is, my lord, being I do civil cases, that's why Order 41, Rule 27, in an appellate, when a suit is being filed, and when you prefer an appeal, and when, my lord, there are 3-4 grounds are there. So even then, Order 41, Rule 27, before a division bench or before any court, appellate court, my lord, either he takes up the matter or, my lord, he remands it before the trial court to decide that issue. So your lordship is not that powerless to not take into consideration of the subsequent events.
Particularly when public interest.
When public interest is involved, my lord, your lordship can look into it. Larger public interest. So 2022, 7 SCC, page 247. Only I'll do paragraph, I'll just mention paragraph 7. Your lordship can note down 7 to 9.
2022.
2022, 7 SCC 247. Para 7 to 9.
This is on what point?
I'm sorry?
This is on what point?
Order 41, Rule 27. Appellate courts. Jurisdiction of the appellate court. Jurisdiction of the appellate court. But I think, my lord, the judgment which I cited 2014, that makes it, to my opinion, that makes it very clear. Subsequent event can be taken into by the court. Where? Yes.
This question of public interest.
One more judgment, Nine. Yes. I will just argue tomorrow, my lord.
Complete your
I-
citation, just give the citation.
Yeah, this is, my lord, these are the cases. Yes, 2022 SCC online, SC 1460.
1460.
Yes, I will just hand over the judgment. Para 24, 27 to 29. I'll just hand over.
This is on what point?
Principles of res judicata.
My lord, principle of res judicata.
Even in the same proceedings, it is binding.
Same proceeding, my lord, why I am saying,
29-9 order.
but 29-9,
23 order.
my lord, 23-9.
29-9-23.
My lord, why I am showing this, I mean 29-9-2023, after hearing me, on the point, the additional facts we have brought before the court.
No, subsequent events.
Subsequent events, the state has brought the subsequent event, so we brought this additional fact before the court.
State has
Now, my lord, this matter, my lord, has taken into consideration by the division bench. So now, it will be like a residue. Already the London division bench has taken up the matter and the 4 points were formulated. Am I clear to your lordship? 4 points were formulated.
What you call the division bench taking up the matter in the criminal.
No. This court.
In this,
yes.
this proceeding.
Yes, not criminal, this matter, my MD.
Can you refer to the order?
Yes. I'll read that order. I brought that order also. Your lordship, that order is of, this order is 29-9-2023. 29-9-2023.
SIT formation, lordship.
Yes. It's a court's order, my lord. In this case. Yes.
Order dated
29-9-2023.
Item 1 did. Order sheet of the course. Item 1.
Not only in separate proceedings, but also subsequent.
No, my lord, what we are saying, the matter which your lordship now on this point your lordship is putting us there, whether we can go into that aspect of the matter, that court, and this is what the Supreme Court has said, just 27 I have given, the principle that doctrine of res judicata is attracted not only in separate subsequent proceeding, but also at a subsequent stage of the same proceeding. This is what I am saying, my lord.
Well, it will also be covered by issue estoppel.
Yes.
Before lordship rises, I have to just give an update, lordship, on one judgment.
I think my learned friend with Mr. Kohli will get time. Let him finish.
Well, no, Digantada, you're getting it wrong. You have quoted a judgment which is stayed by the Supreme Court.
No,
I
I'm
just
sorry.
need to tell lordship
If it is wrong, Mr. Kohli, you will get time to give a reply. You will get time. Tell the
I'm not
court.
replying.
So
I'm just saying that the judgment you have relied upon is stayed by the Supreme Court. How can we not inform the court?
My judgment, which is quoted, whether right or wrong,
you will not
it will be decided by the.
I'm saying it's stayed.
Into a private debate.
Mr. Diganta Das, I mean, how can we not inform the court that a relied upon judgment is stayed by the Supreme Court?
No,
I mean,
you
this
can.
is not a point.
No, you can. But when your turn will come, you please tell us.
I'm just simply
I
saying
think
that
this is a
before
very
lordship
good-
rises,
Yeah,
you have made a comment.
Mr. Kohli, please, Mr. Lal, don't enter into a private debate.
Of course, we don't wish to. I'm not even interested in. But that Darkunga judgment is stayed by the Supreme Court. That's the only information that I have to give lordship.
State, it doesn't mean it is inoperative. It is not an overthink. State is inoperative हो जाएंगे.
झारखंड स्टेट है ना 17 से
Lordship is rising now. Yes. Sir, my lord, I will continue tomorrow from 2 o'clock.
And Lordship, I will request for the VC link. My colleagues there will make a application for that.
Please make a request, will be
Yes,
accommodated.
sir. I'm so grateful, Lordship.
I could not hand over to Mr. Kohli the judgment because no one is here on the other side.
No, we've noted it. We've noted all of them. No problem at all.
I think my learned friend Mr. Chaudhary is there waiting his turn, being a fourth down player, which I was there before the division bench. Fourth down player, he is waiting for his turn.
After Mr. Das.
Yes.
तो नोट करके ना स्टे वाला हम अपने आर्गुमेंट में बोल देंगे 17(4) का जस्टिस बिंदल का
It was.
Only if there is any query by your lordship can put it, my lord. If something is troubling your lordship, you can put it and we'll be eager to answer it, my lord.
Okay.
Grateful, Lordship.
We are not required to pass any orders because.
Yes.
Oh, no, sir, your argument will be.
But once I complete this, I have a list of dates which I prepared. And which points, I will argue that point I will give it before your lordship. So your lordship gets it.
The submissions of Stacy Bogor, Learned Senior Counsel in WA so and so. Assisted by his learned instructing counsel. It's concluded, reserving right to reply. The submissions of Mr. D. Das, Learned Senior Counsel, assisted by Mr. S. Das, counsel for the Learned Counsel of the petitioner, remains inconclusive. Next one, all the respective senior counsel of instructing counsel and the counsel for the parties are present, including Mr. N. Kohli, learned senior advocate, appears through video conferencing, and Mr. H. Chaudhary appears through video conferencing. As indicated earlier, list on tomorrow. 6 9.
Single bench item 1 for orders.
Maybe, Your Lordship.
Yes.
That, I have instructions to withdraw this review, please.
Upon instructions, Mr. R. Sharma, and counsel for the petitioner. Has instructions to withdraw this review petition. Next one, Mr. A.K. Sayawala, and counsel for the respondent numbers 1 to 7 is present. Next one, the matter stands dismissed on withdrawal.
Right.
What's up?
Item 2 with 3 for orders.
May I please, Your Lordship? Actually, in this case, my lord, I was handicapped with the absence of my senior. K. Chaudhary, just he has left for Delhi. They informed my lord. Now, what has happened, my lord? In this case, some new development has come, my lord. After filing of the review application, I came to know that the conciliation application was filed for conciliation of the matter by the aggrieved woman before the committee met.
Okay.
And most probably, it was rejected, I was told, my lord.
Conciliation.
Conciliation of the whole proceeding, my lord. So she
can-
wants to.
How can it be possible?
Now
Lordship?
she wants to, she has got, that her advocate.
I'm appearing for my lord with the complainant of this present case, please. After initiation of this case, the honorable court revert back the matter for to be tried before the internal complaint committee. There is a provision, section 10, my lord, under that the complainant filed an application for review. Actual thing is that, my lord, she is trying to settle down in her life and she wants to get married. And she don't want to get herself involved in this, all these litigations. There are numerous litigations pending between both the parties. So, my lord, this is my instruction, my lord, I can file an affidavit, my lord.
It has to be filed because we can't take cognizance of
On a verbal.
something on a verbal
my lord.
note.
Otherwise, my
Because,
lord, I- the
because we
communication-
can note it down, but the problem is that if it turns out to be incorrect, then you are personally in problem.
That is why, my lord, I want to, my lord, file an affidavit, my lord, placing all the materials before the honorable court. And this is the communication, my lord, I have received from my client, my lord, that she had written to the, my lord, NRL, but her prayer has been rejected.
Condition law. Condition, I know. It was to ICC, this, na? I think ICC, this. No. That's all this.
It will,
Lord, I want to. Lord,
prevention of The sexual harassment in workplace.
Assurance দিব লাগে না ওকে কোর্টে দিলে বেলেগ কথা কোর্টে করতে এটা হয়নি Huh? No, 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 he, constitution, no, he wants, he gives a letter for, no, tomorrow koko assurance দিব লাগে all will do. That is for you all to decide. আমি তো assurance দিব বলি not force করব নোৱাৰো না the case নকৰো কেতিয়া against আমি কিছু নকৰো
What is the name of that act? Protection or
this
sexual harassment?
sexual harassment
Sexual harassment
of women at workplaces, which is known as the POSH Act.
Posh Act.
No, I forgot the name. I was sending, asking my court master to find out protection of women, so that's why.
Sexual harassment of women at workplaces. Prevention and.
No. Everything else I can understand. Name of the act is something I.
It's very long also.
It's a posh act.
Posh
but
Act.
It's
Okay.
termed as. Amendment হল নাকি নাই?
আছে amendment আছে. That's fine for us. But no condition has to be. How to meet your knowledge and it's fine. If they. Both sides are agreement correct.
Was this conciliation subject to how the matter is presented on the next date? But this conciliation is before initiating of an inquiry.
Exactly. Now we do not have the power.
That stage is over, man.
That stage is over.
That stage is-
That's the only thing I wanted to say.
They do not have the power now.
No, we won't say anything once they are. asking
Let them
for an
file
inquiry.
his petition. And it's basically between the two parties to decide.
Yes. Okay.
Yeah. তুমি ঠিক করছো আমি
ঠিক করে দিয়েছে।
এই ঠিক করছে ঠিক করছে এখন দেখেন
বাতিব না বিয়াত।
Mr. P. Kotokil and counsel for the petitioner raised for an adjournment. Mrs. M. Hazarika and a senior counsel, assisted by Mr. D. Khan, learned counsel for respondent number 1 and 2, and Mr. J. Roy, learned senior counsel,
4 mile.
assisted by Mr. Ash Sharma, BP Sharma, learned counsel for respondent number 4. Are present. Next para. Mr. M. K. Das, learned counsel appearing for respondent number 5, as well as Mr. P. Kotokil and counsel for the petitioner have submitted that the petitioner as well as the private respondent.
His presence is not required for the 14th statement. He can only process on the vice versa.
Desire to file an affidavit to bring on record certain subsequent developments. Stop. They may either of these, they are permitted to do so by filing an affidavit at least 2 days prior to the next date of listing. Next para, list on.
What is this good meeting?
Let it be listed on 12th, my lord.
Let Mrs. Hazarika take a choice.
12, how much time will you need to file the affidavit?
These 5.
Huh.
2 weeks like least after 17.
After he wants some time, so let him, otherwise again he'll come. So what about lordship 19th Monday?
I have got no issue. You just check your time. I am giving that liberty to you.
19.
19th is fine, lord.
Okay, 19/5/2025. Okay. We are not saying so, but you want to file an affidavit, that's why we stop.
Let them file them on Friday, by Friday you file them, so that we get the copy on Friday.
The issue which is there, lordship said whether he will be allowed to process, or in his presence to examine. So that has already been by other high courts have settled it by. It said that he can cross-examine, but there is no provision, but there is provision, but it's not necessary that he has to be there for at the time of taking examination in chief.
Otherwise, if the entire process materializes, then we can file a withdrawal petition also, then.
Let him file lordship only
Wait,
then,
wait,
no
wait,
point going
boss.
through the other aspects now.
No point, she's right. When we are adjourning the matter, no point applying.
And lordship, if he wants to kind of withdraw, then where is the scope for
There
anything?
is no, yes,
Scope for anything.
then my lord, section 10 goes.
We
You
don't
are not
know.
doing it
We
under
don't know.
section
We
10.
won't say anything right now.
Initiation of.
Right now, we won't say anything.
Yes.
It's.
That is
it-
only after filing of affidavit by him.
That will be better.
We have nothing, my lord. May be Raji to kya karega, Gaji mate.
Let us see.
He's married
I
Old-
know.
to someone else.
Old English saying, you must cross your T's and then dot your
Dot your
I's and
I's.
all. Then we see what comes.
Yes.
Okay. Item 2 and 3 also goes then.
Yes,
Can we pass a common order?
yes, lordship.
Okay, 2 and 3 common order.
Obliged.